Right. Is Senator McCray in the House? Senator McCray is not here? Okay. All right. Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Tuesday, January 20th, 2026. We have 12 bills on the docket, and we are going to start off with Senator Sidnor. You ready to go? Senate Bill 55. Actually, belay that. We are now going to start with Senator McCray, who's just arrived, and we're going to go Senate Bill 111. Senator McCray, welcome.
How are you doing, Mr. Chair, Mr. Vice Chair, members of the committee? I come to you in reference to Senate Bill 111, joined by Nina Thimelis from Al Government Relations and I want to say Major Law, but Lieutenant Colonel. He got like fast tracked, but Lieutenant Colonel Loeffler. Mr. Chair, I'm here before you for a bill that you've heard before in reference to just the out-of-state tags or how rampant and prevalent that is becoming within our state. This passed out of the House. It was heard before the Senate. We just didn't make the cut. I know that NBA has weighed in. I know that they're supportive, but it may be some additions, as I spoke with Administrator Nasser, and there are a number of organizations that also support it. But just want to make sure that I just stand in solidarity with my delegate who's led on this respective effort, Jackie Addison.
Whoever would like to come up to the mic next.
Good afternoon, Chair Smith and Vice Chair Waldstrecker, Waldstrecker, and honorable members of the Judicial Proceedings Committee. I'm Lieutenant Colonel Derek Loeffler, and I'm here to offer favorable testimony in support of Senate Bill 111. Senate Bill 111 tackles a significant compliance, public safety, and equity issue on Maryland's roadways: the improper registration of vehicles by Maryland residents in other states, particularly Virginia. Recent data shows that in November 2023, over 101,000 vehicles were registered in Virginia using Maryland addresses, and by June of 2024, that figure rose to approximately 111,000 vehicles. This situation exists because Virginia's registration rules allow non-residents to register vehicles in their state. Maryland law, in contrast, requires new residents to title and register their vehicles with MBA within 60 days of establishing residencies. This loophole has real consequences. First, on the fiscal side, Maryland potentially loses up to $12 million annually in registration revenue to support the Transportation Trust Fund, funds critically needed for road maintenance and safety programs. Second, it affects public safety and insurance compliance. Out-of-state registration has, in the past, allowed uninsured operation by avoiding Maryland's insurance requirements. From 2023 through 2024, Baltimore has recorded 14 fatal crashes involving Virginia-registered vehicles, representing 10% of our fatal vehicle accidents, and 7,075 non-fatal vehicle crashes, representing 47% of our non-fatal accidents involving Virginia-registered vehicles, underscoring the risk to our communities. Third, approximately 11% of these out-of-state registrations are tied to unpaid violations, parking citation tolls, and automated enforcement penalties, undermining enforcement and shifting costs to compliant drivers. Senate Bill 111 strengthens the statutory framework and enforcement tools to ensure vehicles owned by Maryland residents and primarily operated here are registered in Maryland. It promotes fairness, supports public safety, and protects critical state revenue. For these reasons, I urge favorable report on Senate Bill 111. Thank you.
All right. Good afternoon, Chair Smith, Vice Chair Waldstrecker, members of the committee, Nina Thimelis, Director of Government Relations, for Mayor Scott, here to testify in support of Senate Bill 111 on behalf of the Baltimore City Administration. As you've heard, the data is very convincing for the issue that we have in Baltimore City and across the state with vehicles that are improperly registered to other states. Just a couple more data points that I want to add, as the testimony before me was very thorough. But in 2024, Baltimore City issued 51,863 parking citations to vehicles with out-of-state tags, and 41% of those were from Virginia. During 2025, a year where we had expected to see some potential decreases because Virginia did change some of their insurance policies, we saw 68,224 parking citations that were issued to vehicles with out-of-state vehicles, with 48% of those being from Virginia. And so that represents over 30% increase in parking citations. And while that's just one data point, I think the fatal crashes, the number of crashes, the other types of citations that we see just show that this problem is continuing to exist in Baltimore City and across the state, and that we've actually seen an increase in the issue overall. Based upon the report that was provided in January of last year, much of which is included within the fiscal note for this bill, we know that something needs to be done, and so that's why the city administration strongly supports and urges a favorable report on Senate Bill 111. Thank you.
Excellent. Thank you very much. Thank you, Senator, and thank you both for your testimony. Are there questions from the committee for the proponents of the bill? Senator Sidnor.
Thank you very much, Ms. Thimmelis, actually.
Say that again.
May I speak to Ms. Thimmelis? When I look at the witnesses, the Maryland State's Attorneys Association, they have two different positions. One's favorable with amendments and one's unfavorable. So I'm not certain which position that they're taking. However, in the written testimony that they submitted, they said that they felt that rather than having, since this is a civil matter, rather than having the state's attorney's office to bring actions, that language on, I guess, on page 3, lines, I guess it's section 2 and section 3, where you have the counties, state's attorneys seeking action, that they believe it should be your county attorney or your city attorney. Yeah, I'm assuming you're fine with that?
So we are willing to meet with the state's attorney's office. Our law department had a slightly different read on that, but we want to make sure that we resolve the issue to make sure
So
that
what's the different read?
That the local attorneys would not be the responsible party for bringing these types of in rem actions within the court system.
So you all would prefer the state's attorneys to do it?
I can follow up with the detailed information from our law department, just that goes through line by line their interpretation of what that would mean for our city attorneys versus the state's attorney.
Thank you.
Further questions from the committee? All right, seeing none, thank you all very much. Thank you. Thank you, Senator.
Y'all have a blessed day.
All right, that'll conclude the testimony for the proponents of the bill. We'll now hear from the opposition. Is Mr. Katz here?
Okay. Mr. Chairman, members of the committee, my name is William Katzoff. I'm an assistant state's attorney from Anne Arundel County. I'm here on behalf of the Maryland State's Attorneys Association, essentially in opposition to it, although I might add that for the first 2 pages plus, we're fairly neutral because it really doesn't impact on us. Then when we get to line 23 on page 3, all of a sudden things begin to change because there's an enforcement mechanism that would have us file a proceeding in rem. Now, 40-some years ago, when I was doing automobile forfeitures, I filed proceedings in rem to try to take cars away from drug dealers when they were being used in a felony drug offense. But here we're simply talking about the registration of motor vehicles. Now, when there's a charge of an unregistered motor vehicle, we don't get involved. It's a non-jailable offense, and we would not personally prosecute the traffic violation. But we are being asked to prosecute the case in the event that to try to get the car properly registered. An in rem proceeding means that we would file it against, say, for instance, a 2020 Honda Pilot. By the way, not my car. But at any rate, we would still have to serve the registered owner. Now, we may try to personally serve him or her. That may or may not be successful. If we're unsuccessful, then we have to use substituted service. I don't know whether that means registered mail, whether we publish, or whether we put notice on the courthouse door. In any event, I realize that it says may as opposed to shall. But nonetheless, I don't think it's something that we should be involved in to simply file an in rem proceeding against a car to have the owner properly registered. I would suggest that Everywhere else, it talks about the administration until we get to line 23 on page 3. I think either an attorney general assigned to the administration or to a county attorney who is used to filing civil proceedings should be the entity that files the proceeding in the circuit court. So for that reason, we would oppose the bill unless lines 23 and thereafter are taken out.
Thank you, Mr. Katz. Senator West.
Mr. Chair, I don't think I've heard about in rem action since I was in law school. And that was quite a few years ago, as I am now 75 years old. So it's interesting to hear you talk about that and to read that portion of the bill. It would seem to me that since the bill up until that point imposes fees and increasing fees, I think it's $7 a day, and that mounts up, that the logical remedy would be to sue the person for all the fees. Would you agree that that would be a more logical way of dealing with this problem than getting the state's attorneys to file in rem actions against the automobiles?
I would agree. And Senator West, I'll be 75 in March, and I haven't, it's been a long time since I've had civil procedure, so I certainly would not, and I used to do car forfeiture, so I'm out of practice, to say the least.
Thank you very much. Appreciate your answers to the question.
Any other
I wish,
questions?
believe me, I would sure like to have some of those years back.
All right, seeing no further questions.
Thank you.
I think that completes the hearing on Senate Bill 111. Thank you.
Folks here? Yeah. All right, we're going to go. All right, that'll conclude the hearing for Senate Bill 111. We'll now move on to Senate Bill 45, and then we're going to tack over to Senator Sidnor's bill. But Senate Bill 45, Senator Brooks is here in the back. Senator Brooks, welcome.
Okay, good afternoon, Senator Smith, Vice Chair Waldstreicher, and members of the JPR Committee. Thank you for the opportunity to testify before you on Senate Bill 45, as Vehicle Law Speed Monitoring Residential District. For the record, I'm Senator Ben Brooks, representing the 10th Legislative District in Baltimore County. Now, the purpose of this bill is to localize the decision-making from installing new speed monitoring system. This legislation is about local control and community safety. Today, nearly every county in Maryland must seek state approval before placing speed monitoring systems in residential neighborhoods. Even though local government best understands their own roads and safety concerns. This bill simply transferred that decision-making authority to local level. Speed cameras are an objective, non-biased, non-partisan tool that reduces dangerous speeding while minimizing police interaction. At the same time, this legislation recognizes the importance of community input, ensuring placement do not disproportionately impact disenfranchised communities and are driven by safety needs rather than revenue. Empowering local government to make these decisions allows for more responsive, transparent, and equitable traffic safety solutions. We respectfully ask for a favorable report on this bill. And I have my two panelists here, and I'll let them make their presentation, then I'll entertain any questions, sir. Okay. Oh, okay. All right, Sarah, go ahead.
Thank you to the chair and members of the committee for having me today. My name is Sarah Sample. I'm here from the Maryland Association of Counties, and we are here to support Senate Bill 45. Thank you to Senator Brooks for introducing this legislation. You have already heard what it does. From a MACO perspective, we think that this wisely recognizes that residential areas are similar to school zones, and they are likely to have higher densities of family and children and more vulnerable communities that might need the protections that are offered by these cameras. And this simplifies the process similar to the school zone process by making it statewide. We understand that you do not take decisions like this lightly. We certainly do not at all, but you have put this trust in us before, and we're asking you to do it again so that we can protect our mutual residents. The other thing I wanted to say is thank you so much to this committee for organizing an automated enforcement meeting ahead of session. Thank you particularly to Senator Love. You invited us to the table. We were able to share and discuss ideas, and we really appreciate that. And we know that that timing and willingness, it does not go unrecognized, and we're very grateful for that. So thank you. And all the information that we shared during that meeting, I'm happy to share with anybody else on the committee that would like to see it, because we definitely want to further transparency and trust in this process. So thank you for your time, and we would urge a favorable report on Senate Bill 45.
Good afternoon, Chair Smith, members of the committee. Bill George with the Maryland Municipal League here today in support of Senate Bill 45. A lot of the points have already been made, so I'll keep my testimony short and sweet. This is an opportunity for local governments to control their own destiny in terms of roadway safety. I can tell you anecdotally, our members hear from their constituents all the time on things that they see going on in their community, and roadway safety is almost always at the top of the list. Those municipalities that have a school in their jurisdiction and can construct a school zone around it and have an automated traffic enforcement system have reported, decreases in incidents. There are a handful of municipalities in Anne Arundel, Prince George's, and Montgomery counties that have the authority to place them in residential zones, and we simply ask that this be a statewide authority for then the locals to make the decisions that's right for their community at their time. So with that, we ask for a favorable report.
All right, thank you very much. Questions from the committee? All right, seeing none, thank you very much, Senator.
Thank you.
That's it.
Chair. All right, good.
Got off the hook on that one. All right. All right. With that, that'll conclude the hearing for Senate Bill 45. We'll now move on to Senate Bill 55 with Senator Sidnor.
All right, good afternoon, Chair Smith and members of the Judicial Proceedings Committee. This is a reintroduction of a bill from last year. If you all recall, during last year's hearing, I made mention of an incident that had happened to me and my family in 2019 during a vacation where we went to Virginia, and an officer pulled me over along with the rest of my family for what he said was, eventually what he said was me driving too slow. In all actuality, it was me trying to follow the traffic signs that were not very clear down in Virginia, and it had one speed limit for a certain time and another speed limit for another time. And I will tell you that particular incident, it really was not an incident that I felt comfortable with. And at the time, I could just remember thinking about Philando Castile and the countless of others who had gone through these routine traffic stops and didn't make it. So, and I've been pulled over before, and certainly it's stressful. And I've had some real good officers who were able to bring down that stress level. That's not always the case when one is being pulled over. This particular incident, this officer was condescending. It felt as though he was attempting to emasculate me in front of my wife and my kids. And what was it all for? As I said, it was for driving too slow in the left lane. And I explained to that officer that I seen a speed limit of 45, but he rudely told me that was only when the lights were flashing. This distressing experience left a mark on me. Not only did this unnecessary interaction have nothing to do with public safety, but it made my entire family feel unsafe. That same year, after receiving a tip from concerned citizens regarding traffic disparities, I set out to uncover the traffic stop data from Baltimore County. After some effort, the data was made available, and it was stark. The data showed that black drivers were 73% more likely to be stopped by Baltimore County police than white drivers. Black drivers made up 56.25% of traffic stops in 2018, while making up just 26.1% of the population. It was this revelation that led to the creation of and my service on Baltimore County's Equitable Policing Work Group in 2020. Our work group was organized to analyze available traffic stop data in Baltimore County and make recommendations on policies and practices on how to ensure equitable policing and bring greater transparency and accountability to the department. In that work group's 2023 traffic stop deep dive report, Baltimore County's police chief, Robert McCullough, has recognized the implementation of training programs, including implicit bias, fair and impartial policing, active bystandership for law enforcement, de-escalation, and mindfulness. These programs may have had an effect in conjunction with public scrutiny, considering that bias could be inferred in data between 2017 and 2019, but could not be inferred between 2020 and 2022 after their implementation. However, the disparities after traffic stops occur continue to persist. The report stated, and I quote, "Black drivers are far more likely to have their person or vehicle searched for probable cause during a traffic stop, even though these stops are less likely to find contraband for black drivers compared to white drivers." The report also found that, quote, "Hispanic drivers are issued citations at a higher rate than both black and white drivers." And while I appreciate our chief's efforts, and I believe that he and his police force are likely the rule rather than the exception, it is these disparities that spur me to seek and introduce a legislative remedy. Data produced by the Equitable Police Work Group in 2024 has revealed that 56.2% of traffic stops involve black drivers, despite making up 33.5% of the county's population. And while some improvement have been made after accounting for population growth of the black community, traffic stops remain significantly disproportionate. When looking at the data, that is an irrefutable fact. Today, I am here to testify in support of Senate Bill 55, which would change the categorization of certain low-level traffic infractions from primary offenses to secondary for enforcement purposes. When the law enforcement officers conducts a traffic stop, there are two categories that stops can fall into: primary or secondary violations. Primary violations allow an officer to initiate a traffic stop because of an immediate risk to the safety of the driver and others on the road. Most traffic violations, such as speeding, disobeying a traffic signal, running a red light, for example, or tailgating, are considered primary violations. Secondary violations, in contrast, are more minor violations. Secondary violations can only be investigated after a stop for a primary offense has occurred. An example of an existing secondary violation includes an item hanging from a rearview mirror. First, Senate Bill 55 adds non-safety related infractions to the list of secondary violations in Maryland. Under Senate Bill 55, the following violations would be recategorized as secondary offenses: driving with the registration plate expired for less than 4 months, displaying an expired registration, driving with only one white headlight, driving without an illuminated license plate, driving with one outside rearview mirror when the interior rearview mirror is obstructed, and driving with excessive window tint. In addition to this categorization of offenses, the legislation requires officers to document the reasons for traffic stop and others stops on the citations or police reports resulting from the stop. And if an officer fails to abide by this requirement, any evidence gathered in the stop may serve as a basis for the exclusion under this exclusionary rule. And I might say, and I have next to me our Attorney General, and you all should have his testimony where he lists about 5 different things amendments that he would be seeking to this. I have them up here because I think of the ones that he had, was one that we may have to continue having discussions with, but for the most part, the rest of them are acceptable and would be considered friendly amendments. So, by shifting police traffic enforcement from making these types of stops to focusing on dangerous driving, jurisdictions can promote road safety and overall public safety while advancing community trust in police. The resources, the time, the energy that go into traffic stops for non-safety reasons present a significant opportunity cost. It is far more important for the safety of our roads for our officers engaged in traffic enforcement to be focusing on dangerous behavior that can be life-threatening, such as reckless driving, speeding, running red lights, and driving under the influence or tailgating. Additionally, when an officer pulls over a vehicle on a roadway or highway, they are placed at risk by vehicles at high speeds that are passing by, especially when their vision is obstructed by inclement weather or lack of daylight. In 2025, two Baltimore City, I'm sorry, I'm gonna skip that part. But what I can say is that, again, traffic work is inherently dangerous for everyone, especially for our black motorists. When I introduced this bill last session, I told the committee that the legislation was the beginning of a conversation to address an indisputable problem of racial disparities in traffic stops. However, this bill raises important questions of how we can balance the need to reduce these police encounters with the need of safety on our roads. It has necessarily prompted a considerable and continuing conversation with law enforcement and constituents alike. And this dialogue has resulted in a variety of alterations to last year's bill. Provisions from last year's bill, including driving without functional taillights or brake lights and driving in the bus-only lane, have been removed. It has also been specified that driving without an outside mirror will remain a primary offense when the interior mirror is also obstructed. Additionally, while the draft bill in front of you includes a recategorization of littering as a secondary offense, I have with me an amendment to also remove that change from the bill as a result of these conversations. In last year's hearings, law enforcement raised concern that the then Senate Bill 292 included language that officers could face disciplinary action for enforcing secondary offenses in the absence of a primary offense during a traffic stop, and mandate the evidence gathered will be inadmissible in court. Consequently, we have elected to remove some of this language as well. In conclusion, recategorizing non-safety related traffic stops that are disproportionately enforced on Black and brown Marylanders will enhance public safety by refocusing strained police resources on serious traffic offenses that threaten road safety and rebalancing police workload towards violent crime. Through our ongoing dialogue, we have significantly narrowed and altered this legislation from last year and have struck a strong and smart balance with equity and safety concerns. With that, I would urge a favorable committee report, and thank you.
Chairman, members of the committee, good afternoon. I am Natasha Dartigue, Maryland Public Defender, and the Office of the Public Defender seeks a favorable report on SB 55. You may hear today that these minor traffic stops are an important tool for law enforcement. Let me tell you what the tool actually does. In 2023, that tool stopped Black drivers at 43% of traffic stops, although they were 32% of the population. It issued 57% of equipment citation to Black drivers, and in Harford County alone, it stopped Black residents at nearly 3 times their population share. Yes, it's a tool, but for what? Data says that it's being applied with stark racial disparities. You'll hear perhaps that it prevents crime, leads to bigger arrests. The truth? Most result in citations or warnings. They're creating distrust in communities where we need partners and putting officers at unnecessary risk. Using minor violations as pretexts to investigate isn't efficient policing. It's unfocused, it strains resources, and erodes public trust. This bill does not eliminate that tool, it sharpens it. Officers keep full authority to stop speeders, reckless drivers, and impaired drivers. They can still cite violations in this bill. What changes is that they need a legitimate safety reason for the stop itself. SB 55 is an effective tool. One, in 3 ways. 1, community cooperation. Safe communities need trust. 2, officer safety. The bill reduces unnecessary stops, protecting officers while focusing on genuine threats. And 3, proven results. Jurisdictions that have passed this bill have seen a decrease in crime as well as an improvement in officer safety. The question is not whether this is the right thing to do. Data says that it is. The question is whether Maryland will join the growing number of states to choose effective, equitable public safety. I ask that you enter a favorable report to SB 55. Thank you.
Going to testify in support of Senate Bill 55 with amendments. And for the record, I'm Attorney General Anthony Brown. I want to start by thanking Senator Sidnor. Thank you not only for introducing this legislation for a second time, but also your leadership on this very important issue. I've submitted written testimony that provides greater detail and background on the positions I'm articulating today, along with detailed references for the facts and the data that I may present today and that certainly are in the written testimony. The sponsor was talking about traffic stops and how dangerous they are. And they're not only dangerous to the motoring public, but they're also dangerous to law enforcement. Nationwide, between 2014 and 2023, 150 officers were killed by being struck by vehicles, and 292 were killed in automobile crashes, accounting for nearly 40% of all law enforcement deaths in the line of duty. 40% of the deaths of the line of duty from 2014 to 2023 nationwide due to traffic accidents. But the motoring public also faces danger. Nationwide, and you've heard both of the previous presenters talk about these facts, over a 5-year period nationwide, more than 400 drivers or passengers were killed by police during traffic stops, and that's not counting people who are armed or fleeing from violent crimes. And what's undeniable is the racial disparity in these stops, and you heard the data right out of Baltimore County. So this is not just nationwide and Maryland immune, but it's happening right here in Maryland. Study after study shows that black drivers are stopped at higher rates than white drivers, and once stopped, black and Hispanic drivers are searched more frequently. So here's the critical question. When we're making stops for purely non-safety reasons, does the risk justify the reward? And the evidence suggests that it doesn't. Other jurisdictions have proven that we can do better. I've laid that out in my written testimony. For example, after Los Angeles limited stops for minor infractions, non-safety violation stops dropped from 21% to just 12% of all stops without a degradation in their law enforcement capability. That's why we support this bill, reducing unnecessary traffic stops and addressing racial disparities is the right thing to do for Maryland. Now, that said, we do need a few amendments to the bill. These amendments will protect public safety while achieving the goals of reducing racial disparities in traffic stops. And my written testimony provides additional detail on each of them. First, we need an alternative enforcement system through the MVA. Officers who observe violations like broken headlights should report them to MVA for repair orders and citations by mail. Second, officers need authority to stop drivers who commit multiple secondary offenses. One broken taillight might not be dangerous, but multiple violations show someone who's ignoring the rules of the road entirely. Third, and perhaps the most significant amendment that I present to the committee, the bill requires officers to state all reasons for a traffic stop. But sometimes officers stop a vehicle for a traffic violation when they're also investigating the driver for a violent crime based on information obtained from victims and witnesses, and requiring them to reveal that investigation during the stop puts victims, witnesses, and officers in danger. And finally, the evidence suppression provision needs to be amended, if not removed. We should not risk letting guns and evidence of violent crimes be excluded based on minor procedural issues, especially without clear guidelines from the court. We've had an opportunity to speak with the Office of the Public Defender, with the sponsor, Senator Sidnor. We think that we can achieve common ground consensus around all of these amendments to make them stronger. So we support this bill and certainly its goals. Urge the committee a favorable report with amendments. Thank you, Mr. Chairman.
Thank you to General Brown, our public defender, and Senator Sidnor. We'll now open it up for questions. Senator, you want Senator Muse first? Senator Muse, go first.
Yes, thank you. I want to thank General for being here, and we're going to hold him over because he's here to wholly support my bill. And everyone you see behind him are actually lawyers from his office who are here to support this bill. So I want to thank you for that and just bring it to your attention. Thank you. Thank you.
Move it.
There you go. All right, with amendments. All right, Senator Folden, and then Senator West, and then Senator McKay, and then Senator James.
Okay. Mr. Attorney General, could I ask you a couple questions real quick, and then I'll have some for the bill sponsor, but I may have to come back around. I'm just curious, in your testimony and in your letter, you reference, or even in your testimony, you reference like Los Angeles, I guess or I don't know if California as a whole did it, but they passed it. Are you familiar with how many other states have done like this type of?
My testimony, I think I listed 8 jurisdictions, some are states, some are municipalities.
Okay.
Yeah.
And out of the whole country. Okay. I'm a little confused as to how in your first your first paragraph, you talk about, and you referenced it today, that 150 officers were killed by being struck by a vehicle and 292 officers were killed in automobile crashes. And you referenced that as like a 39% of law enforcement officers killed in the line of duty. I'm just interested, how is that relative to this bill?
How is this?
Because this bill is about enforcement of pulling over people. It's not about, officers being struck by a vehicle or killed in motor vehicle crashes. That would imply that they were responding to something or something else. I mean, it's kind of misleading when you have that type of statistic.
Certainly, the goal is not to be misleading, and I do make reference to the report that cites that. There are many cases within those numbers where the traffic accident involves the police officer conducting this traffic stop. Okay. And maybe they're in their vehicle, maybe they're standing outside of their vehicle. It's happened in Maryland. It's happened around the country.
Yeah, it's unfortunately happened in Maryland. We've had a police officer run over, but it wasn't on a traffic stop. And then, so you understand my confusion on that data being presented, how it would be misleading to people reading this to think that 39% of law enforcement officers were killed as a result of leading to secondary offenses that are being eliminated, because that's not actually what they were actually doing at that time. Some of them may have been.
As I mentioned, the goal is not to be misleading. The goal is to put forward the facts and the data with references to the report. So when you see the report, you'll have an understanding of what those traffic stops and the deaths that happened, the context in which it happened. So the goal is not to be misleading.
Yeah, no, and I appreciate that. I just wanted to give clarity for everyone listening. And then you talked about police shootings on traffic stops. Did you go down that further to find out how many of those were found to be justified versus not justified?
No.
Uses of force. Okay. is it safe to say that an overwhelming number of those were justified uses of force?
I'm not going to speculate. Because I wouldn't
Well,
do that.
because
You would not want me to do that.
Yeah,
because
no.
just 3 years ago, you gave me and my office the authority to investigate and prosecute police-involved deaths.
Oh, I didn't.
And one of the things, no, this General Assembly did. And one of the things that you don't want me doing is speculating on facts unknown and whether something was justified.
I think
or not.
off of giving you that authority, since you brought that up, that I think it's clear that overwhelmingly the investigations you've done into law enforcement and police-involved shootings have been overwhelmingly justified uses of force.
Oh, now that's a question about Maryland's experience.
Yeah.
The answer is yes.
Thank you. And then I had and I'm going to apologize, Mr. Attorney General, because I don't know if you brought this up, but I think somebody mentioned about Baltimore City or the mailing of citations or something. Was that you, sir? Okay, thank you. So I just stepped out with Senator McCray. Baltimore City is already having an issue with their speed camera and red light camera citations. And part of the issue is that they are issuing citations to people across the state that were not the offender. And the reason I point that out is they actually materially altered their registration plate, whether they put white duct tape over a 4 that makes it look like a 1, which changes who the offender is. And so, you know, and I brought it up to Senator McCray because this is a policy thing that I'm asking them to look at, but Baltimore City's policy is yeah, we can see that it's not your car, but you still got to come to Baltimore to testify, or we're going to fine you and keep giving you penalties. This becomes a tool that actually damages and harms people because they're not following their own policy. So now we're taking this issue and we're looking to eliminate, and I apologize, I got a lot of things going on here. Oh, here we go. We're looked into, I have concerns when we have, we're trying to, a person driving on a canceled, suspended, or revoked registration. And actually, this might be a better one for the sponsor. I'm sorry. I'm sorry, Mr. Agee. Senator Sidnor, you mind answering this one? Thank you. Apologies. So we're having already issues in Baltimore City that are well documented by people even in my district that have to go to Baltimore, and they're complaining to me because they're not even following their own policy. So we're looking to give a wider breadth, if you will, of this mailable citation program, which already has its own issues just in Baltimore. But we're allowing vehicles that are canceled, suspended, revoked to drive on highways.
Can you point that out in the legislation?
Yeah, I mean, it's you.
I just want to know which section you're talking about.
Yeah, I apologize. On page 3, line 19, and then you say that they're only allowed to do this as a secondary action. So everything beyond that would be considered a secondary action. Is that correct? Page 3, line 19.
All right, so you're talking about 401E, which is a prohibition for the owner of a vehicle from knowingly allowing it to be driven on a highway in the state if the required registration fee hasn't been paid.
I'm talking about page 3, line 19.
And that's section 13401E, right?
It's under E. It's the next line. It's the next section down.
All right.
It's paragraph 2 under E. Yes.
All right.
So it says, and then in bold, so that's how you can tell. Everything in bold is the part where you want to make everything beyond that is a secondary offense.
All right, so we're looking at making modifications to 13-401D and sections 13-401E.
Yeah, so those sections are any canceled registration, suspended registration, or revoked registration. So by an officer seeing that a registration plate has been suspended, canceled, or revoked, and they have no other issues at that point, by this piece of legislation, they would not be able to stop that car. Is that correct?
As a primary offense, right?
Hold on, I want to make sure, just for the construction of the statute, like, I think what you're reading is that subsection only applies to section E. So it's just to make sure that that's clear. So that only applies to subsection E, not the entirety of what's below it, just to subsection E.
What it does
So it's E and it's D. Right.
It says if a vehicle has not been, a registration fee has not been paid for, the owner of the vehicle may not be willingly, and then it goes under F. This is F. If it's under a second thing, it's all under making it a secondary violation.
So the modifications on line 19 through 21 are referred to 17 and 18.
17 and 18.
E.
This subsection only.
The modifications on 14 through 16 refer to lines 12 and 13. And for the record, since we're talking about this particular section in 13401D, I took a look at GoCap's information online for traffic stops, and from 2016 to 2024, there were only 327 traffic stops where 13401D was cited as the reason. If you look at sections 13401E, 18 traffic stops based on this citation. So what are we talking about?
All right, I'll defer until I'll yield to the next one until I look at this and get these apparently lined up right for me.
Thank you.
Chair. Senator Sidner, I had the pleasure of meeting with a couple of the advocates for this bill, I think it was yesterday. We had a very engaging conversation, and I think we ended up saying that we should discuss the bill after the hearing and see if we couldn't make modifications to the bill so that I could come on board. So along those lines, I really appreciated the Attorney General's testimony suggesting 4 amendments, 2 of which were ones I had in mind that I wanted to discuss.
And as I said, everything that he talked about, I think outside of the exclusionary piece that we have to talk about are acceptable. I thought they made sense.
Good. Well, that was going to be my question. Do you accept the Attorney
Yes.
General's suggestions?
Absolutely.
Okay. So you referenced your own amendment you want to make to it. We have 4 from the Attorney General.
The section dealing with littering, that should not have been in the bill.
The one about throwing glass and cans and
trash.
tacks and nails, things like that on the road. Okay, so that won't be in the bill.
No, it will not be.
Okay, so what you're saying is you're willing to sit down and discuss the bill and make reasonable modifications.
Senator West, as I stated last year and I stated this year, was the beginning of a conversation. So we're putting this stuff out there, trying to get to a happy medium where we can have the most people satisfied with where we're trying to go.
Great.
So absolutely.
And as you know, that's what we frequently do in this committee.
Absolutely.
We work things out. Let me go back to your distressing personal story about the time you were down in Virginia with your family. To begin with, I note that it occurred in Virginia, although I'm sure perfectly positive things like that have occurred in Maryland as well.
Right.
It was certainly an appalling situation, but it predated the days of body cameras. And my understanding these days is since we require law enforcement officers all to be equipped with body cameras and have them on when they interact with members of the public, my understanding is that when people make complaints these days about how they were treated by law enforcement, the state's attorneys and the other authorities take a look at the body camera footage, and if there's a problem, the police officer who engaged in the unacceptable conduct gets disciplined or otherwise dealt with. Wouldn't you say that's generally the case?
Honestly, I don't know, but I will say that my traffic stop did not predate body cameras.
Was your policeman in Virginia wearing a body camera?
Yes, he was. In fact, I have the tape at home or the CD at home.
Did you?
It's unfortunate. I asked for it. I filed a complaint, but I have not been in the right headspace to still watch that video. I have it, but I won't watch it.
Since we required the body cameras, I haven't heard horror stories from Maryland about complaints being made about officer conduct captured on body cameras and nothing being done. It may be happening. If it is, we should probably take a look at that and try to deal with that.
I think the body cameras, as you know, that was my legislation in 2015. I think it's been a real positive step towards making both law enforcement and civilians act a little differently towards one another. In fact, I have a body camera piece of legislation coming this upcoming session for the chiefs and police. So I do believe in body cameras.
Good. I'm looking at the testimony of the Maryland Chiefs of Police and the Maryland Sheriff's Association, in which they report that if the officers are required to cite each and every violation observed in order to justify the stop, it will take discretion away from them to not cite for things they don't want to cite and cite for something lesser. Is that a concern? In other words, if the person was speeding, but not speeding too badly, and a speeding violation would put points on the person's record, but there's also, to use your bill, the window's too tinted, they might only cite the window being tinted and would not go after the violator for the speeding as well. But based on this language in the bill, they might have to also put down the speeding violation, and therefore the driver would have to go to court to deal with the speeding violation. Does that cause you any concern?
Again, I think some of that is going to be addressed through the amendment that the Attorney General was speaking to. But to answer your question, no, it would not.
No, okay, well, that's a clear answer. Okay, thank you. I love clear answers.
Maybe. I'm sorry.
And I guess
inside joke.
The final issue is the Attorney General said that somehow the MVA might be able to go after people. I'm not sure that's going to work in the real world. We can talk about that when we sit down behind the scenes to talk about maybe amending the bill. But my concern is if the policeman cannot stop to give a citation for one of these violations, how in the world are we going to remedy the violation? What alternative is there? Are we simply going to allow people to drive down the highways, violating the law without any way of stopping them or remedying that situation?
I so appreciate that question.
Good.
You know why I appreciate that question? Because I took the time to go and look at GoCap's, all the data that our 100-plus police agencies send into GoCap so that it could be captured in the data dashboard. And I wanted to make certain that I had this for the record to share with everyone. And I mean, really, what are we talking about? So on page 3, where we're looking to modify and make 13401D a secondary offense, and this data is from 2016 through 2024, okay? 327 traffic stops. When you look at 13401E, 18 traffic stops. On page 4, line 3, where we're talking about 13-411F, 19,562 traffic stops. 13.7.
I'm sorry, 13411F?
F, that's where we would make a secondary
I think
offense.
it's on page 5. Yeah, how many stops?
19,562, and 1341-411F is a prohibition against driving in Maryland with any expired registration plate.
And there were 19,000 stops?
19,562.
Okay.
And again, this is over 8 years. On page 5, 13701, we break it down into 13701B, 27 stops, 13701A, 10 stops.
I'm sorry, B was how many stops?
27.
27.
Over an 8-year period.
Okay, and the other was C?
701A, 10 stops. And this is all the data that law enforcement has provided to the state.
So it seems to me that information sort of cuts two ways.
It can.
There are only 10 stops.
So
What
why?
are we doing with a room full of people worrying about 10 traffic stops?
Right, so
over 10
until
years?
you think about the effects that it has on someone that's been stopped. Again, if you've been pulled over in a predicament that I was in, one stop is too many.
So clearly the big issue in your bill, the thing the bill is mostly about, the 19,562 stops for driving with expired registration plates, correct?
Oh, no, and I have more if you don't mind.
Oh, I'm sorry.
Just walking through the bill.
Go ahead.
I won't talk about the littering, which is coming out.
Yeah.
It was in 21-1111D, 251 stops. 21-111A, 14 stops. But again, that's going to come out.
Okay.
22-203, the headlamps requirements. 22-203B, 2,134 stops.
Wait a minute, 22-203B,
And then 22-203.
how many stops? I'm sorry.
2,134.
Okay.
22-203D and 22-204, under 5, according to the data.
Under 5 stops.
Under 5.
Okay.
22-204F, which deals with tail lamps or separate lamps having to be illuminated
Yeah.
near the rear license plate. 6,206 stops. Let's see. 22-403D. Actually could not find anything as a reason for the stop. But when one looked at 22-403B, 22-403A, or 22-403C, you had 1,640, 1,249, and 63 stops respectively. And finally, dealing with the tent, 22-406I1, 66,017 stops. And again, you're right. You're right. That data, an opponent of this legislation might take the data and say, well, that's it, until you're that one on the other end. A proponent is going to take it and use it as I'm using it and say, wow, the pushback, this isn't all that many stops over the course of 8 years. So why is this a tool that you find necessary to keep when it's really, how much is it being utilized? And especially when you're talking about the damage to a community that's dealing with this driving while black or driving while brown that it causes. And again, one of the things that I want to be clear about, because I've had some conversations, no one is trying to impugn anyone's and calling them racist or anything. But I know James Baldwin, when he had talked, it was I think he was back in the 60s, he was in an interview, and someone had asked about him bringing up race, and he pretty much said, you know what, when you look at the United States and when on Sunday morning, it's the most segregated time in the United States. He says, look, I'm not going to put what I believe on you, but I got to deal with the evidence that's before me. And the evidence shows vast disparities. So the question then becomes, rather than those who are being opponents to keep pushing back and say, stop taking away our tools, the question is going to be, how do we deal with these disparities? And this is just one answer, which is why I say this is a conversation. I don't know, obviously the bill as presented wasn't the direct or the best answer, because I was open to the Attorney General's amendments.
Right. So I think this conversation should be had. I'm glad you brought the bill. I congratulate you. The numbers that you supplied will be extremely helpful when we sit down to talk, talking specifically, mostly about the offenses for which there have been lots of stops, as opposed to ones where there are just a handful of stops. So I think we've set the table here to go on and discuss it further, and hopefully come up with a resolution which will be acceptable to everyone.
I appreciate your question.
Thank you very much.
Senator, thank you for bringing the bill. I had a different question for you, but you had referenced this report and the 19,000 expired tags. So is that in the bill to have that removed? So you will not be able to?
13411F, 19,562, which, right, correct.
Yeah, so is that not a reason to pull you over? That's being taken out?
Again, it's not, we're changing it from primary to secondary. It's not saying that you can't pull over, but it's a secondary offense.
Okay. All right.
Would you mind, Senator?
Please, thank you.
Hi, Debbie Levy from the Office of the Public Defender. I do want to say the intent of the bill is only to eliminate or make secondary a stop where the expired registration has been expired before the first day of the 4th month for failure to pay. And so under F, we also need to tweak the language so it correlates with the other two sections, only focusing on the failure to pay for less than 4 months. And so the section that you...
I want to just make sure, I want to get good information. That's the most important thing. But just for protocol, like, I want to make sure that the witnesses are correct. So please be just brief in the answer, and then we have to rely on the witnesses. I just want to make sure that we're consistent with the application of the protocol. I just want to make sure. But please very briefly conclude, and then
that was it.
Thank you.
Okay. Thank you very much, sir. I have one other question for Attorney General Brown. Thank you, sir, for bringing up some of the amendments and that kind of stuff to see if it's a little palatable. So you had said in your oral testimony about multiple infractions. And so my thing is, how does that process work? How is to be able to figure out those multiple infractions? And if we're not recording them, meaning you've been pulled over for those different things, how do we know that said driver is driving around with multiple infractions?
Well, our position is that if an officer observes multiple secondary offenses, right, one of which might not be a reason to stop someone, but 3 or 4 could be and should be a reason. So if you've got multiple secondary offenses, then that indicates that you have a driver who is entirely, who's willing to entirely disregard the rules of the road and represents a much greater risk on the road. So we would ask the committee to amend the bill so that if there are multiple secondary offenses, that law enforcement could stop them, even the secondary offenses.
Okay, well, I appreciate that. And then this is end up of a statement. You don't have to get up. But my concern was going to be, how do we ensure public safety? It just seemed to me we were watering this down, but taking into consideration that amendment, that should address that issue. Isn't that so? Thank you very much.
Thank you. And I'm so sorry I came in a little bit late, Senator, because I do have a quick question for you. And I do remember this bill from last year. And I remember we were both talking about our traffic stops. But I missed yours, and I don't want to delay, but I don't know if I have any questions about it or comments. So I know you were in Virginia. You were with your family.
Correct.
Right? You were the driver.
Right.
And you had children and your wife in the car.
Correct.
And so a state police or a local police officer report, just quickly.
I do not recall.
It doesn't matter. You got, just give me the nature of it again. I apologize.
Going back to the resort, I was in the left lane, saw a police officer behind me, saw a traffic sign that had 2 different speeds on it, so I slowed down to the slowest speed. It was at that point that the sirens were turned on, and I moved over, pulled over, and the stop happened. So.
Did you get a ticket for that?
No, I got a very stern warning.
Was a warning about, in my family, we call them hat warnings. Does anybody ever heard that phrase?
No.
No, and it has nothing to do with you, but when people, it's usually older people are driving really slow, and I respect and love older people. I'm becoming one. But we say hat warnings because a lot of time older people wearing hats. My father wore a hat. And they are the ones that often drive slow. And sometimes you see on like 95, drivers get pretty frustrated and actually, drive aggressively around them with frustration. Right. So and I'm not saying that was this because you're in a resort, you're not on a highway. But were you chastised for the potential of driving too slow and frustrating other drivers?
I don't recall, and I know the frustration that you're talking about, but this is in the late evening. I'm the only one on the highway. So me driving just under 45 miles per hour, I think the top speed may have been 55. Oh. It wasn't that slow.
No.
But it was
But do you remember what he said? Was
over.
it that he was, whatever his understandable reason, was it like you could be causing some headaches or safety issues.
And as I mentioned, I have the CD at home, or the DVD, I just haven't watched it.
But you brought it up, I guess, because you felt that, where were you, North Carolina? Or South Carolina?
It was in Virginia.
Virginia. But you were using that as a segue into your testimony. So did you get the impression or something said to you that led you to believe that your race played a role in being pulled over?
You get these sixth senses growing up in this country because, and again, as I've mentioned, I've been stopped by state police and left feeling that was a pretty good stop. The officer made me feel comfortable. I was good.
Right.
So you have some sixth sense about these things.
But I don't want to admit this because I had very few, if no tickets really, and maybe it's because I'm charming, I'm just kidding. But I get pulled over on a regular but infrequent basis. And so I've had a lot of interaction. I would say that state police in any state generally seem to be the most professional, put together, and don't betray anything that I can pick up. When I'm at a different level of law enforcement and I'm in certain states, I have picked up feelings of some bias about me, especially if I'm a Maryland driver in Delaware, maybe going to the beach, and other things like that. So I don't think that, I just want to say that I think we can pick up a lot of biases, whether they're real or imagined, and without evidence, I'm not sure what to do, but definitely very local law enforcement have made me feel diminished. Of course, they're frustrated. They believe I've violated some safety protocol too. So, and I always bite my lip because that's not the right time to say or do anything. But anyway, I just wanted to know that backstory.
Like I said, my uncle was a retired homicide detective, so I know when to bite my tongue as well.
And now I would pose this to either or both of you because I am intrigued by racial disparities, try to follow it in other contexts. The idea being, in general, shouldn't, we would treat us potentially suspect when anything happens, traffic stop, employment, just anything, right? Some things, important things, show that one group isn't following the same proportion in their population as they are in whatever that event is, excelling or not, traffic violations or not, so on and so forth. But while that can be evidence of it, I have some doubts about how effective and accurate it is, simply because I'm more of I take each person as they are. I think race is a social construct. I mean, we can see it, but it's a social construct, all the stuff that we think or don't think about it. Right. So for me, the most important thing is not how many white or black, Hispanic, Asian people get stopped relative to their global. It is whether the underlying facts of these cases indicate absolutely no difference or not a lot of difference, evidence that, one group is getting off scot-free or just a lot less invasive or whatever it is, and another group has a lot of data saying very close circumstances, similar, and yet we consistently and over time get higher violations and penalty, whatever it is. So that's what I'm interested in, not so much for me to consider the bill, how they match up with their population. It's how they match up with their behavior and the differences or not between the behavior, actions, and circumstances. Is there any reports or data, maybe you saw it, Mr. Attorney General, I don't know, that would delve into that aspect of it? Because maybe the disparate numbers now would ask you to look, but you'd really have to look beyond the number of whether it corresponds to then, all right, let's open up the hood and see what the facts are and the trends.
And I think you would find any researcher who is worth their salt. I guess they would say that you can't take the population and the number of traffic stops and say that it's disparity because of those numbers.
Right. It's correlation, not causation.
Right. In Baltimore County, the researchers, they took our information and they used what they call the veil of darkness analysis to kind of look at these numbers, and it helps you to determine whether or not there was bias. The veil of darkness analysis essentially says, okay, if we're stopping those who are driving at night when visibility is lower, we should kind of in proportion have the same number of everyone being stopped rather than the disparate numbers that you see during the daytime. And even with the veil of darkness analysis, they still say even that has some of its hangups, because in some more urban areas, you may have traffic lighting where you're still able to see who it is driving and the like. So, I mean, yes, I would say you just can't look at the numbers, and analysis has to be done. Whether or not a statewide analysis has been done, I would say I doubt it. The data's there. We just don't have anyone that I'm aware of that has done that research.
It is my fault for coming in late, so I didn't, so you're saying there was a report done that used the veil of darkness?
Right, so in Baltimore County, because I brought this type of information forth, we created an equitable policing task force. We've worked through UMBC, and UMBC has been looking at the numbers in Baltimore County to determine what was really going on in our county.
And so they have a report?
They have a report that's in draft that I'm trying to get them to have finalized so it can be published to the public.
Because I think for me to get comfortable with the bill, I would want to see that report, because that would be the only thing we know of at the moment that took a look in one county, but and I think what you're saying is they use this veil of dark. Let's see the difference between daylight and nighttime. Right, okay, so that would be informative. That might not get me there, but that would be one more layer. I'd still want to know about the cases. But you, Mr. Attorney General, and you, Senator, have either one of you, or your staff, obviously, looked across the country to see if we can find, not that some cities have, or states, and I was going to ask about that, Mr. Attorney General, you can get to that, have changed the law in some way, but done an analysis beyond the difference in numbers, disparate numbers, to look at the data for these kind of stops and to see whether they're similar, different, the populations, are they acting or behaving or something different, or relatively, are they similar? Do we have any reports like that anywhere that you know of? So, I'll look it up.
Yeah, so I don't have the answer to that, but I will push back a little bit on sort of the premise of your question, in that the General Assembly makes many, many decisions every year in so many areas, in health and education, in public safety, on population data. Sometimes it warrants drilling down to analyze, well, what were the facts and circumstances of each one of those 100 encounters so we can better understand, and sometimes not. And these are decisions that you make. You make them all the time. Are you going to use sort of gross population data like we've presented, and there are some sites in the report, and you may find the reports helpful or not helpful or compelling or not, but you make that decision every day. Are we going to use population data? And the population data here shows that black people are pulled over more than white people, and that blacks and Hispanics are searched more often than white people when they're pulled over. So that's population data. You can accept it or not. You could ask to drill down.
No, I'm saying, Mr. Attorney General, nor did I say we don't use population data. All I said was speaking for myself personally. That's all. And I get health care and some other things, but we're talking about potential violations of the law, and you're right, in sometimes potential dangerous circumstances, and also potentially endangering other people. So I don't, there is a broad kind of thing we could say about population data in healthcare, let's say, or education, but there are some very distinct differences where I almost think that on a threshold of this nature, I just would prefer, it would help me, not criticizing anybody that doesn't want that additional information, and asking, has anybody done that? Because I know researchers, if they have the money and the time, want to research everything, because certainly they want to drill down and find as much as they can. But if there aren't any, that's fine. I'll look around, but if you didn't find any and the senator didn't, then I won't pursue that any further. I just have a couple more quick questions. Sorry, couldn't get it back down. All right, so.
For me or?
Well, I don't know. I think you may have mentioned this, Mr. Attorney General, but Senator, you may have too. I heard that maybe amendments, 3 things might be happening. The idea is if we see the secondary offense, have it mailed in by the officer, and then multiple violations, the officer, even though the secondary couldn't, stop, and then state all your reasons. So just quickly, my thought about mailing in was similar to Senator West. We can address it later. Hopefully we'll work together in this, about just the discretion. I'll give you a good example. When I learned that my daughter had died, I was racing to Baltimore. And at the time, I think I was, and something else had happened in our family. And so I was about 30 days with an expiration, right? So as soon as the officer stops me, it's like, oh, God, lady, I'd like to squirt you if I can, right? So so I know this won't come up all the time, but what does worry me is that I'm sure there's a very consistent, stable, not insignificant population of everybody for which an officer would stop you, check, be satisfied that this is not the time, place, or anything, and would drop it. So we may lose that, I think. And I don't know if we can build in any kind of discretion, perhaps even how the officer reports it out. So let's think about that, because I do want, I don't know how to address that, but I do know there's probably a consistent, stable, small but important population. And then secondarily, I'm a little bit worried about court resources. I don't do it much. I'm sure you didn't either, but maybe we both, at one point in our careers, were in traffic court. So it's already an overcrowded mess. So I don't know where the courts are, so we can talk about that later, and I'm just throwing that out. I'm going to come to a question. Here you go. Multiple offenses. What was your thought on what multiple? Is it 2? Is it 3? Is it depend on one of the enumerated ones we are now not going to stop for? Otherwise, how are we going to do that?
Yeah, I don't think there's a magic number. I think that's
we got to codify it.
I mean, I would think 3 or more. 3 more. Yeah.
Now, here's my last one, and anybody can answer this except Senator Folden, who will answer it later. Multiple times. I'm joking. I really like him. Okay. I'll just use the public defenders. They listed 6. Senator, you're welcome to either one of you. 6 ones. I don't know if it's current, but I wanted to use them because they're just in front of me. So, several deal with expiration registrations, but let me focus in on 2. Driving with only one white headlight. I think that is extraordinarily unsafe and needs to be immediately remedied, right? It is very hard to gauge whether it's a vehicle or a motorcycle. I can't imagine that this is similar to expired plates or registration. That one worries me in the sense of that being very, very dangerous, and I've seen a lot of drivers have problems with that. And then the second one is driving with one outside rearview mirror when the interior is obstructed. I think that sounds really dangerous, and I'm bringing that up because I think we said, none of these offenses are really about public safety. I don't know if everybody would stand by that, given what I just said. I mean, you don't think that bothers me. I think they do directly relate and profoundly to public safety of others.
I would just make one correction. When we speak about the side view mirror missing, it's with something hanging from the rear view mirror. So that's not necessarily an obstruction. That is, for example, an air freshener.
I'm just saying your testimony says driving with one outside rearview mirror when the interior rearview mirror is obstructed. So that would be a secondary offense and we wouldn't stop. I think that's a very unsafe condition for the driver and other people in terms of people, unless the person's committed to staying in one. I just don't think that's I think everybody's been saying these were all unrelated to public safety. It's sort of like, hey, it's like getting your Veep thing. I shouldn't say that. I know that's very important. But, it's like going and getting your car checked for its pollution abilities or hopefully not. Some of those two, and actually there's a third one, the tinted windows, all make me think of unsafety. With tinted windows, what I think is the driver feels emboldened because we cannot see what the driver's doing in the car, and there's no way for us to sort of protect the driver from using the veil of darkness to an unlawful behavior. So anybody that wants to tell me these don't relate to public safety, I'd be glad to hear about that. And any data. And if we don't have time, and I know I'm dragging out, so you can just follow up with data, but, or anything, you know, expert people that want to discuss that these particular problems don't have anything to do with public safety, or very little, when I think they have a lot to do.
So I think prior to you sitting down, I went through each and every one of these offenses that we were talking about making secondary.
Yeah.
And I went through the data that we currently have over at GoCap and went through, and I'll make certain that you get that data.
Thank you.
One of the things I did not mention about all of those numbers were that we were talking about, I think it was over the course of also, I think over 6 million stops. So when you're talking less than 5 stops out of 6 million, I mean, again, what are we really talking about? So.
Thank you.
I'll make sure.
So you saw some data, Senator. I'm not going to pin you down now. We'll talk later. But you saw data where what I just mentioned isn't borne out by the evidence or something.
So I will make certain everyone gets this data.
That would be so helpful. And I think this is sort of the last thematic thing, and maybe it should be for another time. But I'll throw it out there because this will be germinating in my mind. So, you know, unfortunately, the opposition is all law enforcement, practically, right? The people that are involved in enforcing these laws, the people whose lives are doing this kind of work. I don't see any of those people, and there might be somewhere else in the country, people whose lives are invested in this work, saying this is a good idea, this will both address your concerns, or your concerns aren't valid, and public safety, or what am I trying to, that they're not, I don't know any law enforcement saying, yes, great way to deal with the superficial until we have data, racial disparities, but I see it, population data, and no problem on public safety or just compliance with, you know, our vehicle laws, because I don't know who's going to step in. So for me, what does anybody want to give me their thoughts on why law enforcement, just globally without being too pointed, is wrong or not in the right position on this bill? Is it a misunderstanding of the bill? Is it an underappreciation? You know, like we're on the Senate floor, let's keep it at a high level, but I'm just trying to get a sense of why law enforcement all are against this bill, and the bill is so profoundly affects their day-to-day experience and work.
You know, I'm going to push back on that.
And you don't have to.
And I will say that from obviously looking at the panels that have introduced opposition today, it's all law enforcement. But I could guarantee you that there are officers, when they take off their uniforms that look like me, they have issues with the way that these laws are enforced. And in fact, a number of them I've had conversations with.
Do you know if anybody, thank you for sharing that, and I get the sensitivity of it. Has anybody in the country been able to acquire some of that information with discretion and anonymity? You know, that would be validated because everybody's given a number, not a name. Right. But that is powerful information, Senator, and the kind of thing that would move me if I were hearing officers not in, you know, in their official top hierarchical down position, but their experience as law enforcement, white or black, and how they see that, and if there are officers, a lot of them that see this just the way you're describing. Do you know anything like that?
Yeah, so I mean, this is publicly broadcasted, so I would say any officer out there that look like me that want to call the senator's office, make sure you call them.
Yeah. Okay, I'll look around. Thank you so much, and thank you so much for letting me go on and on and on, but I learned a lot. Thank you all very much.
All right. All right, thank you. Senator Charles, or Sidnor, Charles Sidnor, sorry, jeez. I got my bearing back now. So one of the things I wanted to say, and you just brought it up, is that doesn't officer discretion come into play with those that have an issue with it? If they don't think it's necessary?
Right.
If they don't feel safe making that traffic stop, can't they decide not to make that traffic stop?
Yes.
Okay. And then, do we know, did you get any data on how many secondary offenses or relative stops resulted in the seizure of felons with firearms?
I don't know if that data has to be reported to GOCAP, but all the information that I got comes from GOCAP's website, so I could look and see if they have that information. So all I'm saying, I don't know.
Sure. No, I understand. I understand. You looked at GOCAP's, but I just want to say, like, you know, I think it's a pretty common knowledge that there is an inherent, look, no more, two things most dangerous to police officers, traffic stops and domestics.
Right.
One involves matters of the heart.
Right.
The other involves a stranger in the middle, sometimes in the middle of the dark.
Right.
But it's a matter of, that's your job. It's a sworn oath.
Yes, sir.
And so, I mean, I certainly don't want us to stop going and, you know, going to domestics unless they're physical. You know, I want us to be able to go when they're verbal to stop anything from becoming physical. So when I'm thinking about, you know, what leads, and then, you know, after 30 years in police work, I'm grateful to finally have retired this past year, and I'm super, you know, excited about the opportunities ahead. And my family's excited because there has been a pretty significant change in law enforcement in some of the community, in some of the public eye. But I don't think we've ever had a time where we're not more accountable in law enforcement to our communities that we serve with the visibility, the camera technology, the vehicles, I mean, everything they have than we have today. I mean, is that a fair statement?
In terms of surveillance and
no, I'm just talking about
captured?
accountability on the officers with all the things that they're required to do now with their body cameras, the engagements, the ways that if they even fail to, if you forget to activate your body camera, that's punishment. Even though other officers on the same scene captured you in the scene and you were excited and got excited and didn't activate yours, and if it's reported that you didn't activate yours during a violent or a hostile offense, you can still be, even though everybody else saw you, because you didn't do it, you can still be disciplined as a police officer. Is that correct?
I'm going to have to go with what you say.
You can. Thank you. Okay. All right. That's fine. And that kind of leads me to, you know, when it talk about the discretionary part of the officer, right? So we have headlight out. You know, if somebody comes out with a headlight, you know, officer sees it. Maryland's a contributory negligence state. So if they drive down the road and somebody in a motorcycle pulls out or something because they only see one and they think that their depth has changed because of what they're appearing to see, and the officer just drives by, and you got people all the time who are more than happy to report that police aren't doing their job. They're more than happy to call and complain about them. And say, hey, that car went by, right by that marked police car, and it had one headlight out. And he didn't stop it, and it went down there and hit that motorcyclist.
Mm-hmm.
I mean, this body has looked to really reduce, you know, they want to take away any, I mean, they want to make it to where law enforcement officers can have be personally sued for a failure to act in a certain situation.
Yeah, but I think that the amendment that the Attorney General was talking about would help to address that. So again, the way that this is drafted, it's just trying.
But you understand what I'm saying? Like,
I absolutely understand.
We have, you know, officers have, what's the word I'm looking for, Mr. AG? Qualified immunity.
Mm-hmm.
So this would be a strike, literally having to do with that potentially. And we don't want to, you know, and so that would be something that I really want to make sure we have a discussion about, a continued dialogue.
And again, that's what I hope that the committee has.
Okay, so the registration plates, and I agree, and I appreciate you allowing me to regain my bearing. You said there was 19,562. You know, because most of those, I'm going to guess, are because somebody didn't have their front registration plate on, right? Because this is dealing about 2 registration plates.
Which number?
It's 13411A.
Okay.
Okay, so all that section at the end of it.
I think it's F.
Am I messing it up again?
Yeah, I think 13411F is what we're attempting to.
Yeah, okay. Well, it says that any driven, let's say, to play, it says if it, display either its front or rear any expired registration plate. So that would mean also if it doesn't have a front plate on, correct?
Is that correct?
Because we don't put any registration tabs on front plates.
Right.
So if it doesn't have a front plate, wouldn't that qualify as under this stop?
Talking about 13411F. Could you repeat your question? I'm gonna have my counsel.
I'm just asking. Here's my point.
Yes, sir.
It appears to me that that is one of the reasons that we're having stops, and that you were wanting to make this as a secondary offense. My question is, why wouldn't we just put a bill in a structure, in a deficit time that we're having? Why not just put a bill in that we only have one plate on vehicles?
I said that conversation, but
I'm just
we
putting
can
that
have
out.
those
Okay, so again, more dialogue to continue.
Right.
And then I have and Mr. Chairman, I appreciate it. I'm just this is where someone that's been involved in like the structure and discipline of the military coming up, like there's rules, and you raise your kids with rules, and if you give them a timeline, hey, you better come in by 8 o'clock. If you don't come in, there's consequences, right?
Right.
Or when the street lights are on when I was growing up. If you're not in here within 15 minutes after street lights come on,
your butt is
you're in
mine.
your butt is mine,
Gotcha.
right? Why are we going to look at, you're asking about the first day of the 4th month after the registration plate. That is a hard, fast number. They've been notified by MVA that it's expiring. They've been contacted. They're not filling it out. Why are we going to change it to, in that case, why wouldn't we just give 15-month registration tabs for a 12-month payment? Help out our taxpayers, give them a little 3-month window of freebie.
the 4-month period.
So I would best answer that question in saying that, first and foremost, that this bill does not eliminate the tools and the ability of the officer to provide
I can't hear you. I'm sorry.
citations.
I didn't hear you. It doesn't what?
The bill
Yeah.
does not take away the officer's ability to give citations. What it does do.
Ma'am, I know what the bill does. It makes it a secondary offense, which means it's no longer a primary offense, which means it's not a primary reason to stop them. That's what the bill does. So it takes away the officer's authority to stop them, what are now primary offenses, and makes them secondary to where they now cannot go do those stops. I know what the bill is attempting to do.
And essentially, it diverts the officer's attention to those issues that actually go to public safety, to have the officer focus in actually stopping crime.
And how many traffic stops have you done or been a part of in your entire career, ma'am?
I have not engaged in traffic stops, but I have defended individuals and seen the fear in terms of families, especially Black Marylanders, as they have dealt
Have you
in
defended
those
those
situations.
that have had guns taken off of them from traffic stops?
I have worked as a public defender for 30 years, so I've defended individuals in various
It's fair to
circumstances.
say that you've represented a large swath of people that were stopped from a primary offense for different other additional violations.
I have represented individuals who have been stopped as a pretext, absolutely.
Okay, so I'm not sure what you're coming up and saying is relative to my question that I asked.
I was answering the question, but I would ask you to rephrase the question.
I said you have a finite window of time, a 12-month period. They have an expiration. This bill is attempting to have the officer now go out and extrapolate out 4 months of the first day beyond that registration date before they can stop the vehicle when it's very clear when it expired. I don't understand. If that's the case, why don't we just issue 15-month registration tabs but only pay for 12 months and give Marylanders 3 free months?
So,
that's the same thing.
So essentially, it's asking that a citation be issued. So, and correct me if I'm wrong, when an individual is following, an officer is following a vehicle and essentially running the tags, the information is coming back to the officer.
They don't always have to run a tag. They can literally just look and see that if it appears to be expired, there's no obligation on the officer to go ahead and hurry up and run a tag and make sure that it's expired, because even if it is valid and they haven't affixed the registration tabs to update them, that is still a violation of the traffic law.
So we would say that in terms of the efficiency of resources and officer safety, that it would be a better use of Maryland resources to have a citation issued versus the officer risk his life pulling someone on the side of 695 or some other busy highway.
So the Office of Public Defender is more worried about officer safety at this point than they are about the enforcement of traffic laws. That's what you're coming at. You're saying that officer safety is more important to the public defender than the enforcement of traffic laws, and which thereby ultimately sometimes result in the, I don't know, Timothy McVeigh was stopped on a traffic stop, the Oklahoma City bomber, off of a vehicle registration plate, ma'am.
What I say is that the Office of the Public Defender's main concern is addressing racial disparities. What we know in Maryland is that unequal policing exists, where white drivers make up 57% of the drivers, but yet are 25% of the tickets.
I heard
Black
your data,
drivers are 30% of the drivers, but yet make up 50% of the tickets.
I heard your data, ma'am. I'm asking, then again, back to my question, third time is a charm, I hope. Why are we going to go outside? When I discipline my children, I tell them to be in at 8 o'clock and they don't come in at 8 o'clock, there's consequences for those rules. We have tags that have a month and year of expiration. Why are we giving people now a free 3-month window of time that for whatever, I mean, it just seems really simple to me. You have an expiration that's written on your car, you pay your tag. You pay your registration fees. Now, the bad thing is the state of Maryland's made it really difficult, but we got a payment plan because we've doubled everybody's registration fees. So maybe there's another reason why people aren't paying them on time. So why not issue 15-month registration with a payment of a 12-month window so that the sticker showing represents the proper time frame?
I would have to research as to what is the appropriate time frame, but my response is deeply firm in that we have these minor violations that have major consequences and a disparate impact on Marylanders. The problem is that Black Marylanders are stopped more than any other drivers
Ma'am,
in almost every other
I've heard it, every
county.
person that came up, and I've heard that said, and I appreciate that. What I'm telling you is there's other things and other things that you are missing, and it's not about officer safety. It's not even really necessarily about officer resources being applied elsewhere. It's about stopping them from enforcing certain traffic laws that result in stops that potentially lead to other unfortunate arrests.
It would be a non-issue if everyone was stopped equally, but that is not what exists in Maryland.
Ma'am, every stop has video on it. If there's a disproportionate thing on it, then there's accountability. That's why we have the MPAA. I mean, there's people they have recourse if they feel they've been wronged.
But we seek prevention, the before, as opposed to addressing the issue after the harm. We have an opportunity to address the harm before it happens.
So again, it's not about officer safety, but thank you. Senator Sidnor.
Yes, sir.
The last thing I have.
Yes, sir.
I'm sorry, I promise.
No, this is it. I appreciate the conversation.
I do too. I do too, my friend. So here's my concern about window tint.
All right.
It's really high number of window tint. As someone that's been on both sides of it, if we make that a secondary offense, which, you know, I would be of the mind, why not just get rid of the window tint law altogether? Let people have their windows dark. Do you want to do it? Let them have it. That would stop a lot of stops. However, it is very clear in all vehicles that it is not safe at all to put a laminate, a tint laminate on your front windshield. And that's what we're seeing a significant increase of, is front windshields being tinted, thereby obscuring the occupant's identity.
You're going to love this data.
I am going to love this.
Less than 5 stops out of 6 million.
Less than what?
5 stops.
For what? For window tint?
Front windshield tint. This is what the data says.
Yeah, no, and I get that, and that's. But I will tell you, there's a lot more than 5 stops out of 6
discretion.
I'm not disputing it. I can just tell you, as I walk around here, we see windows all the time.
Yeah.
But what you're seeing is, this is what you're seeing in most, and it's become more and more common in recent years. But you will see, and I'm sure the data in GoCap will show you, there's been a significant reduction in proactive law enforcement measures, i.e. traffic stops, by law enforcement professionals in this state due to the fact that there is so much extra scrutiny on them. I think you'll see the data after COVID and down from pre-COVID.
And I appreciate that. And it kind of gives me a small segue. I know our good senator over here had asked a question about law enforcement support and the like. If you look at your list, this bill is the Fraternal Order of Police. They've given a favorable with amendment.
I didn't see that yet.
Yeah. So I just wanted to
look, I appreciate the time. I appreciate the dialogue and the good banter. But again, if we do something, even if you look to make that part, the front windshield is something that is safety based. I mean, when it's nighttime out and there's no streetlights, even if there are streetlights, you can't see pedestrians, you can't see bicyclists, and you can't see through the glass because.
Did we just change this a couple years ago because of people who had certain skin issues and the sun coming in and I thought we just dealt with this a couple years ago.
You would have to have a doctor's note, but it still would not eliminate the pretext to the stop. You should still be able to stop them, and then they present. Am I not correct, Mr. Agee? That at that time they present the doctor's note that would allow them to have that, but the stop would still be valid because it is an illegal infraction unless documented in support of a doctor's note. Is that safe to say, Mr. Agee?
I'll accept that. I've not been in practice.
Thank you. Thank you. Thank you.
Thank you. Senator Zucker's bill last year.
Thank you, Mr. Chair.
Thanks. So, thank you very much for the bill. Thank you all. I'll be very brief because it's been a long colloquy here. But based on what Senator West said, I do appreciate the openness for further dialogue to consider the Attorney General's amendments as well. One thing, we try to do this. We have an obligation to protect the public. So public safety is our number one thing. And things like the headlight, I think, nudge up to that where you don't obviously want, the disparities in terms of the application of the law, but you don't want to weaken the law such that it would, harm public safety. And I think one thing to think about is why there is the disparate application of laws. And maybe instead of taking away public safety guardrails, understanding why they're being disparately applied, is why there's a disparate application, because we do have a response. So I think about the headlight thing. I mean, to me, that seems like you probably need to get that fixed, and that's a public safety issue. Registration, something different. But I do think, just having that as a high level when you guys are sitting down, when we sit you all down to engage in this, just keep that in your back of mind, because we do have an obligation to protect public safety, but also to fight racial disparities, obviously. So.
I do not disagree, and I'm going to go with that, Mr. Chair, but because I would love to understand why? The answer to that question. I would love to know the why and what happened last year in the hearings. And I'm not talking about this one. We had an opportunity to watch the hearing over in the House, and you get the pushback and the don't take away our tools, but then we never get the answer to that why. Well, why is this happening? If you don't like this as a response to dealing with what we see, I mean, it's like you're seeing the tip of the iceberg, but not seeing what's under the water. Something's going on, and we want to get to the bottom of it. And the thing is, I think when you looked at Philadelphia and some of these other areas that have done stuff like this, when certain tools have been removed or modified, these disparities have begun to close. So with that, I rest.
No, I appreciate it. Thank you very much. All right. Excellent. So with that, that'll conclude the testimony for the proponents of the bill. We do have two people signed up in opposition. So if Mr. Eaton and Jamie Dykes would come on up. Ms. Dykes.
Ready, sir? Good afternoon, Mr. Chairman and members of this committee. My name is Sergeant Gerald Eaton, and I am the supervisor of the Harford County Sheriff's Office Traffic Unit. I want to start by thanking everyone for the open dialogue related to this bill. It's going to cut down my testimony quite a bit, so I'm sure the gallery appreciates that as well. I am here in opposition to Senate Bill 55. This bill is framed as a measure for administrative efficiency, but I want to be clear about what this bill actually does. It removes the tools our law enforcement officers use to keep our communities safe. As the supervisor of our traffic unit, that is my main job. Keep the roadways safe in Harford County, prevent crashes in Harford County, and prevent Harford County motorists from dying in motor vehicles. When I see a violation, such as a vehicle driving with one headlight at night, or no headlights at all, or excessive tint, or things of this nature, I'm essentially allowing that unsafe behavior, which could lead to crashes and other offenses. And by making these secondary offenses, we're essentially telling officers they have to ignore expired tags and broken lights, stops that often lead to the discovery of impaired drivers or some other type of criminal offense. We're effectively shielding the very behavior that correlate with unsafe roadways. I want to urge this committee to please keep our roads safe and issue an unfavorable report on Senate Bill 55. Please don't wait for the next tragedy before you realize that proactive enforcement does save lives. Thank you.
Good afternoon. Jamie Dykes. I'm the elected state's attorney in Wycomico County. I'm here on behalf of myself and the Maryland State's Attorneys Association. The talk of amendments is certainly hopeful, but I'm urging an unfavorable report as predicted. As predicted that I would say, it ignores the critical public safety role that traffic stops play. Headlights and taillights are safety features that avoid collisions, injuries, and deaths, bottom line. And if you had been on any side of talking to a victim of a motor vehicle fatality, you'd understand that. If you have seen the in-car camera that we've seen involving these violent collisions. Current and accurate registration plates can help ID those engaged in crime, and they do help get many guns off the street. The littering provision, really, what do we want our communities to look like? The Attorney General mentioned 3 violations, maybe 3 violations, and then a cumulative. I want to ask, in practicality, how many decision trees must our law enforcement officers go through in order to make a lawful traffic stop? As the requirements on them have done nothing but increase. They have to make split-second decisions, and they're likely to be impacted by having to say, oh, well, is that 3 pieces of trash that went out the window, or a not current registration, and do the math on 4 months? That's asking an awful lot of the people who are charged with your public safety and who are held accountable as an occupational standard in ways that most of us never would be, and most of us couldn't tolerate. By removing the ability to enforce the law, you are removing any reason for nefarious actors to comply with it. SB 55 will make driving in Maryland less safe and will cost law-abiding citizens more. Regarding the numbers quoted by Senator Sidnor, I would say that many violations, I take issue over 8 years that only 5 tint violations out of 6 million. I don't believe that that's accurate. Although I do believe that law enforcement, once they tally 1 citation, are not worried with the rest as a matter of their discretion, and that is to the benefit of the driver in violation. I regret that, Senator Sidnor, that you had that experience in Virginia, and that certainly doesn't meet any standard that should be required of our law enforcement officers. I would say that 10 miles under the speed limit, drunk drivers often travel below the speed limit, that is a safety violation, but the extent to which you were treated disrespectfully, that's never appropriate. And as already noted, body-worn cameras serve as a check on that. And our law enforcement hopefully their leadership is holding them accountable. In my experience, that's what I find. The exclusionary rule, of course, generates substantial social costs. It's Senate Bill 55 is like telling a firefighter that they see gasoline leaking from a vehicle and that they shouldn't stop because of the risk of a fire. It's an enforcement mechanism that's effective. I'd ask you an unfavorable report or certainly with significant amendments. If you have questions.
Excellent. Thank you very much. Senator James, then Senator Love, then Senator Muse.
Thank you both. Nice to see you. So just some questions again. I asked a lot before, and I don't want the hearing to go on too long, but I really do want you all to follow up with your colleagues if you can't answer these questions. So I guess I heard you all just generally say that, you know, these secondary offenses are tools to help with public safety. So please send me some information about, I think there is some often information, I think Scott Schellenberger and others bring it to our attention about, you know, the connection between these traffic stops and getting unlawful guns. So that's one. But if you all, you obviously feel that's happening, you probably would say, I've witnessed it and I see data. It's really important when we have a bill like this, we're actually asking the senator to provide what he can. So if you can provide it, and I'll research it myself, or references of things that would be helpful to us to understand your position. And especially if there's a correlation, not a causation, between, there's a different issue, the correlation, but a causation for secondary offenses just being an indice of not just confiscating guns or criminal behavior, but other safety issues that an officer would then come upon once they were talking to the person in the car. Right. So, and then this is joking, but not. I would love to, and I'm going to do this myself, but I'm very curious about what the data shows between traffic stop differences between men and women, if any. So the other thing I wanted to just sort of bring up briefly is, I think people have said, I think my dear colleague here, Senator Folden, mentioned that police officers are certainly under more scrutiny. So, so two questions. One, and I think we were saying our communities are safer. I'm not sure, but there's extraordinarily reckless driving going on since COVID. And I've had police officers, especially and I witness it all the time. I mean, I do not go the speed limit, but I understand about the upper limit where I should be. And I have people blowing. I mean, blowing. They're going 100, they're going 90, they're going 105. So I know that's a little different, but the reason I'm even bringing it up is any sense you can give me about the status of our roads and safety that might be relevant to this. And again, you don't have to write it, just send me some links. That would be helpful. In terms of mailing in, again, you can address this later. I gave you just my own horrifically tragic situation for myself, but this is not, I'm not unique. There are, I think, a consistent group of people, steady, that once the police officer pulls you over, here's that, I got pulled over more recently, and the police officer felt terrible because why did I have some registration issues? We had a catastrophic house fire. I lost my house and my vehicles, and we just didn't have, ladies, it sounds like I have the worst life ever, but, tragedy happens, but I keep going. So, I mean, police officers are like, oh, man, like, get home safely. When you get a chance, fix your registration. So I am a little alarmed, and anything you all want to address later about that discretion and how it might be affected. And in terms of the resources for mailing these infractions in, and I'm going to ask the court, I don't know if they're here, but I might reach out to the court system just to see how they would address the increases, right? Because there's an awful lot of secondary traffic offenses. Lastly, address today or later the idea that the Attorney General brought up about having them state all the reasons. I can imagine a very savvy law enforcement officer sees a car with a door a different color, a bunch of banged up stuff, maybe it's rattling a bit, and there's a secondary offense, but he's kind of he's looking at a vehicle that doesn't look great, maybe not truly in violation of anything. Then he stops the car, probably might be more likely to have stopped that car because of how it looks, how in disrepair it looks, or how it sounds, or even like if there's darks. So for me, I just want you to respond to whether it's workable that they state all the reasons, what you interpret that to mean. I mean, I don't know if that means you can stop for hunches, like, in my experience, a car in this bad repair and a secondary offense is likely for me to reveal more police intervention is required. So that's a lot of rambling stuff, but get back to your colleagues because we're certainly pressing Senator Senior for information, and we would want to ask you to help us with information you have that makes you confident when you testify against the bill. Thank you.
Thank you, Mr. Chair. Good afternoon. Thanks for being here. So we heard a lot of data today, and picking up on the conversation that the chair had with Senator Sidnor, how would you suggest that we address that? Because Maryland has had a very long history with disparate treatment of Black motorists, and that continues as we see in the data. So if not this, then what?
So I don't disagree with that at all, with the disparate data. We have to do something to correct that. when we're talking about safety equipment in vehicles, this is not something we're seeing typically during daylight hours. Headlights out, driving at night with no headlights, tag lights, things like that. You don't know who's in the vehicle, especially when we discuss heavy tint. There's no way for me to know who or what is inside that car until I actually make an approach and speak to the driver.
Okay, but my question is, if not this, then what? How do we get at the root of what's going on, the rest of that iceberg that's out there?
I feel it comes back to education. Education for drivers to keep their vehicles maintained and up to speed, and then and education for officers to talk about, how and why we stop cars.
Okay, thank you.
A couple of questions, because I may have misunderstood something, and I apologize if I did. First of all, I hear saying over and over again that, maybe not as much, that a lot of these, pulling people over for these offenses have led to multiple arrests. Let me give an example, like guns, right? How often does that happen in the larger scope of things?
So I don't have specific numbers for like gun arrests and things of that nature. I can tell you that in Harford County, my unit reviews every DUI arrest that's made or impaired driving arrest. And it is a large, large number that are stops made because of these, like, quote, secondary offenses. No headlights at night, failing to use your turn signal, improper braking, things like that. It's very seldom that we catch a vehicle, say, speeding, and we find out they're impaired. It's a lot of times these secondary type offenses.
Okay, and secondly, I heard you, I believe, ma'am, who said that often officers have to make split-second decisions. I think you were referring to when they're driving down the road and they see such an offense. What is a split-second decision about a registration that is, that in violation of that? What's a split-second decision about that? And I do think that all officers can do math, so I think it wouldn't take them very long to look at this and do the math, even if they have to drive an extra 2 blocks before they pull them over. And I keep hearing this as two major reasons why we should not have this law, and I'm just trying to figure out why we, an officer can't do the math or split-second decision about something like registration. Why is that relevant?
So I certainly could have been more articulate on that point. I think the idea is that there are many more requirements in the last 5 years that have been placed on law enforcement. So them knowing the rules, right, precisely, and then knowing how to apply them in any situation when they're driving down the road, and if they're in traffic enforcement, that there are lots of decisions that need to be made. The more complex those decisions become, the less likely they're going to engage in proactive policing and keep our streets safe. So that was my point. I was probably less articulate.
Because I think, and I'll start with this, I just think it's probably safer for an officer to drive an extra 6 blocks while he's trying to figure out whether or not to pull them over than anything else. But I thank you all for the work that you do, and I appreciate you. Thank you.
Thank you, sir.
Thank you very much. If I could have our Harford County Sheriff.
Yes, sir.
First of all, your video last year was funny. I thought it was a great piece of lobbying. I thought some distortions there a little bit because we got a whole lot of emails and phone calls from some real angry people, but it was certainly effective and got the job done that you wanted done. With that now said, traffic stop data from the Governor's Office of Crime Prevention and Policy show that despite making up roughly 16% of Harford County's population, Black drivers comprise 40.8% of the total traffic stops and 49.5% of registration-related stops conducted by your Sheriff's Department in 2024. If stop practices were race neutral, why do we see Black drivers stopped at such a disproportionately higher rate than their population share?
Again, I haven't seen those numbers. I don't have an answer
But
for that
these are
question.
numbers that you all reported to the state.
The GOCAP numbers?
Yes.
Yeah.
So no analysis? You have no
Again,
idea?
I think it comes back to education. Education for the police, education for the motorists about keeping their vehicles up to spec.
So black
and
folks need
things
to
of
be
this.
more educated?
I can tell you that I personally do not look at a driver when it comes to a license plate issue or a safety equipment issue. I look at the
You may
vehicle
not.
and I see the problem and I make the traffic stop.
But the data is saying something different about your department, which is really what we're trying to get at. And I believe my colleague had asked the question, and you're going back to education, but you can be educated up to wazoo. Something's going on. And I don't know, and you all are out there. And this is my answer to what the data is saying, and you all are saying, no, don't take away our tools. So then the question is, what's going on? Because I would guarantee, and I could be wrong, but I doubt that it's your belief that black drivers are nearly 3 times more likely to be breaking the rules than white drivers, right?
I would not say that, no.
I thought so. So something's going on. You all are our experts, and I'm looking to you all for answers. Again, last year was about starting a conversation. You saw the Attorney General step up and say, look, there's about 5 different things we want changed here. I was open to them. We're going to make the modifications. I'm looking to work in partnership. I'm not in confrontation with law enforcement.
And we would agree, and that's why I said at the beginning, I do appreciate the conversation and the modifications, and I am willing to discuss this bill further so we can get to equal ground.
So then the next question, and it was asked by my colleagues, but just to put a fine point on it, everyone keeps talking about the guns that are confiscated during the stops. That information isn't reported. The only information that's reported on this particular site is traffic stops, percentages, arrest percent, and search percentage. I would assume that you all would know how many guns are being confiscated during traffic stops. I mean, you have a wonderful, wonderful social media that puts up people's faces and shows when you have the confiscations. Do you not have the data that supports this stuff?
I can certainly contact our crime analyst and get that data for you, yes.
This committee, I think we would love that. Thank you.
Certainly do that, sir.
To our state's attorney,
Yes, sir.
I'm going to ask you a similar question. If traffic stops are truly based on objective, race-neutral factors like safety violations, how do you explain that the data that shows that despite making up 28% of Wacomico County's population, black drivers comprise 52% of traffic stops conducted by your sheriff's department in 2024?
I don't speak for our sheriff's department, and quite frankly, I cannot tell you the reasons for that, and I don't wish to speculate as to that, but it's a very good question.
How about the guns? Would you have an idea on how many guns are confiscated in your county as a result of traffic stops?
No, sort of
Can you get us that data?
statewide, the number is between 70 and 85% of guns are confiscated off traffic stops. I don't know how many of those are secondary, what would be considered secondary stops under Senate Bill 55.
But could you get us that data?
I'm sorry?
Could you get us that data?
I believe other state's attorneys across the state are. I will check into that, and I will do my best to compile something from Wacomico.
Because when similar efforts were done in Philadelphia, the Driving Equality Act, which restricts police from stopping drivers solely for low-level violations, since its passage, Philadelphia police actually recovered guns during more traffic stops than they did previously, despite making 70% fewer stops. Stops of blacks fell by 54%, while other stops for more serious violations, like offenses, it happened. So, I mean, even trying to draw this correlation between stops and getting the guns off the street, law enforcement at times, it comes, and the state's attorneys, you all tell us this, but it's getting to the point where I'm like, I don't want to hear the narrative anymore. Show me the data. And you said that you didn't believe, I guess, the data that I quoted, but it's what's reported.
No.
And it was specifically about Senator Folden's comment about the front windshield. I mean, if you're talking about others, yes, the numbers are different, but it was a specific data about a specific point. So me, I like to try to be a data-driven lawmaker. And again, I'm getting to the point many of us, we've been here since 2015. Many of the people came in here in the same class. So we've been around long enough, and it's like, show us the money, show us the data, so that we can make good decisions on policy, good policy for this state that makes everyone feel safe and protected. Are you able to help me with that, getting that information?
I can certainly try. I can certainly try. Our data collection systems in different offices, we are now standardizing those pretty much. So I don't know how far we're going to be able to go back, but I'm sure for 2020.
He's got a bill for that, too.
Did you
He's got
support
a
my
bill for that one,
legislation?
too. Just so you know.
Did you support that?
What's that?
Did you support that bill? Or we were trying to give state's attorneys more money to collect better data?
So
Or did you oppose it with your association?
That's not quite how I would characterize it, Senator.
Your association, y'all really opposed it.
Not how I would
Thank you very
characterize
much. I appreciate your time.
Thank you.
Officer, Deputy Sergeant.
Yes, sir.
So the training, education, and also another part of that would be important, it would be the oversight, and that there's a responsibility, is there not, under the current legislation, that supervisors have to review a certain number of, as a part of the evaluation process for the employees?
For body cameras?
Yes.
Yes, sir.
So, and in that, that is, you know, they're required to review every piece that there is a complaint obviously filed on, but they're also required to do periodic spot checks like each month or during the evaluation period, is that correct?
Correct. We have multiple checks per month, just like spot checks, that's what you call them, random reviews of videos.
And that is to do, what is the purpose behind that?
It's just to look for policy violations, make sure there's no discourtesy complaints, make sure there's nothing we can improve, both from officer safety and a community engagement standpoint.
And it's not even discourtesy complaints, it's just that we're doing it as a directive to ensure that not only are they in compliance, but that we're avoiding those type of complaints, that we're using it as a proactive opportunity to call those officers in to give them additional education, training, or whatever. If we see, hey, you could have handled this better.
Yes, sir.
Here's another strategy. Is that correct?
That's correct.
Okay. At nighttime, and I'm not even talking about an attended window vehicle. Let's be very clear about this. At nighttime, can you tell the race of the violator in front of you when you pull them over?
No, typically no.
During the daytime, with a tinted window vehicle, can you tell the race of a violator in front of you?
Again, how dark are the windows tinted? Most times the answer is no. Most times.
If they're darker than 35%, which is the Maryland legal limit.
There's no way. That's pretty dark. People don't realize how dark that is.
Correct. Yeah, because windows already come with like, what is it, 8% or something?
Something like between 8 and 10, yes, sir.
8 and 10. Okay. And then I guess my last question is no, actually, I'll just leave it there. I appreciate your responses. I just want to point out that there is the evolution of the law enforcement profession has seen great strides in the past 5 years as far as trying to navigate, and there is recourse for anyone that has an aggrieved concern that is documented. Is that correct?
That is correct.
So many of these concerns could be addressed, and because this body passed it, even if those aggrieved concerns are found to be not sustained, that the officer was in compliance after a civilian review board reviews it and it goes to the ACC and it comes back, does that piece in their disciplinary file ever go away?
It will show that the complaint was made and it was investigated, and the
disposition.
The disposition at the end.
Does it ever go away?
I don't believe so. No.
No. In fact, it's the only profession in the state of Maryland that requires their HR file to be open for everyone to review. Is that correct?
That is correct.
I tried to get everybody in this legislative body's HR file open for public review. And you know what they did? They didn't vote on it. That's kind of bad. I think if it's good enough for the law enforcers, it should certainly be good enough for the lawmakers. Accountability is important. So we have this transparency in place, and I just wish I could see that, you know, there is an aggrieved course, there is a responsibility to do the proper evaluation, training, and oversight, and it was established by this body, and yet we're finding that there's still not, people were not happy with that. Is that fair to say, is why you're here today?
I would say that that's not fair to say, in so much as that, yes, for me, this is all about safety and nothing else.
Right.
It's not about race or ethnicity, it's all about safety.
Correct. Thank you. Thank you, Mr. Chair.
Senator Senior was asking some very good questions, and it just, a light bulb went off, and I don't know if we could get this, but I'm trying to look for at least one of these secondary offenses that's sort of very, no pun intended, black or white, which means like your registration is expired or it's not, right? That seems to be one that is one or the other. And I don't know if you all can help me with this. I'll try to do it myself, but I'm going to put you on the hot spot and say, I'd like to see if we can get, if not statewide, a couple of counties where we can grab a day, pick any day, February 1st. No, that's my birthday, let's not. But, and say, I'm sure AA could do it. I'd like to see how many individuals, anonymously by race, on that day have a registration that is expired. I have no.
That would be more from the MVA than
maybe
law
so.
enforcement.
Okay, maybe so. But you all are.
We could tell you how many vehicles were stopped for an expired registration that day, but as far as.
No, I'm trying to look at very objective data, and I really get the point of disparate treatment. And sometimes it is what it is, and sometimes it's not. So you got to look beyond that, at least, all right, you don't have to. I need to look beyond it. And so what I want to see is if I can pick just one. I don't know because I haven't read the whole bill, and I'm only going off the public defender, who is broadly describing six things that would be now secondary offenses that you can't stop solely for. And I only think registration plate expired is a very like black and white one about, because I don't think displaying, we really could figure that out without a traffic stop or driving with one headlight. But we could just by data look at registration and who's expired and who's not, and you could even pick 3 days, whatever we could do. So back me up when I call the MVA, but you also might want to weigh in and say, if they would work with you, just, hey, we have a Senate bill, senators going to ask for it. They asked us to see if we could facilitate it. And let me know if they're cooperative or not.
Certainly I will.
All right, thank you. But do get back to me. I think there's it's a starting point. It's not an end point, but it's a starting point to look at some data. All right, thank you.
Thank you very much. All right, with that, that'll conclude the testimony for Senate Bill 55. We'll now move on to Senator Heddleman with Senate Bill 20.
Thank you very much, Mr. Chairman, members of Judicial Proceedings. I am Shelley Heddleman, Senator from District 11, and I am be back before you today to present Senate Bill 20, this year's iteration of the Family and Law Enforcement Protection Act. We do have some amendments that actually I just got back shortly before this hearing, and I'm happy to provide the amendment and the reprint to the committee. I don't have copies for everybody, but I do have some that I can share. This bill is about keeping individuals who are in interpersonally violent relationships and law enforcement officers safe. It is about closing some loopholes that exist in current law. And I want to give a little bit of a background, and then we will have our two witnesses who have personal experience working in this arena to provide some more light on the issue. And let me just say a little bit by way of background, too. Before I did this work, many, many years ago, I ran a domestic violence program. So I'm familiar, I mean, it was decades ago, but certainly very familiar with individuals who are living in relationships with partners who are abusive. And sometimes that abuse is very well hidden in the family, and there's a whole dynamic and a cycle of abuse. So it is really important to know about that, to know about the environment that we're about to talk about. It is a public health issue, and it is often very deadly. And unfortunately, far too many people are living in dangerous relationships, and we just don't know about it at times, and these relationships become more and more dangerous when a firearm is involved in them. The risk of, and there's been quite a lot of research on this, the risk of homicide in a domestic violence incident increases 5-fold when an abuser has access to a firearm. And this is also an issue that disproportionately affects women. reality is that more, of course, there are women who abuse their partners, their male partners, but more often than not, it is a male partner that is abusing a female. We also know from research and experience that the time that is most dangerous in these relationships is when a partner is trying to change the dynamic, right? Domestic violence is about power and control. And again, as I said, it's about this cycle. And when someone tries to upset and change the dynamic, that is when, more often than not, that is when violence is more, there is more potential for violence. And it is immediately after when someone is trying to get protection from a court or the criminal justice system or the civil legal system, that dynamic again is changed, and then that danger is heightened. There are a number of, well, I want to talk a little bit about the data too here. We know that between 2019 and 2023, 237 Marylanders were killed in interpersonal violent homicides. 75% of those were with firearms. And in 2024, this data was separated out. There were 41 more individuals who died, and 95% of them were women. Again, this is the most dangerous time when someone is going to get, we do, and this committee was certainly instrumental in creating a civil protection order process where someone can go to a court and can seek a number of different things. They can seek the access to a home. They can seek barring contact. They can seek child custody through that process. When they go to a judge, they go and they get what's called a temporary, they can try to get what's called a temporary protection order. What this bill does is this changes that process somewhat by closing some loopholes that currently exist in law. Right now, it is up to the discretion of the judge to determine whether a firearm should be relinquished at this stage. And this bill would say that if a firearm exists, it does have to be relinquished. This bill also creates a process where it is the court can determine in a more comprehensive fashion whether there are firearms in the home, and it asks a series of questions. It adds to the questionnaire when someone completes to seek a temporary protection order, and it helps law enforcement know more fully whether there's a firearm, where it is kept, et cetera. Right now, there are too many, it's like Swiss cheese. There are too many holes in the system and too many times where it's just too squishy, whether there's a firearm, whether the firearm, even if it has been relinquished, actually has been relinquished. And this bill tightens up those processes to make sure that there's accountability. We want to ensure that there is that it doesn't matter what your zip code is right now to determine how safe you can be when you're in an abusive relationship. The removal of a firearm from this toxic environment will create an added level of safety that should be a statewide policy rather than allow it to be determined by each individual jurisdiction. There are a number of other states, some not only blue states, there are a number of other states that have this requirement, that it has been constitutionally upheld. Texas, West Virginia, not exactly bastions of states that have strict gun safety laws on the books. And there are a number of other states that are listed, and I believe in Karen's testimony, that outline who else is doing just what we're offering here. Finally, I just want to say that the solution in keeping people safe is not arming victims, it is disarming abusers. And again, this is a temporary situation. Before a final protection order is in place, the person can retrieve their firearm once the temporary protection order and the final protection order is expired. Law enforcement has the duty and obligation to follow up and make sure that that is being kept track of, and make sure that those forms are also being kept track of. I urge a favorable report, and just really believe that this is another avenue that we can implement to ensure both safety and protection of law enforcement officers. As I think one of our colleagues said, that domestic violence situations certainly add heightened danger to our law enforcement, and it, as I described, it also adds heightened danger to victims and survivors who are trying to get help. So with this improvement in enforcement and victim notification, establishing clear relinquishment procedures, which we do, and requiring the relinquishment at the temporary protection order stage, we will go a long way to help keep our friends, neighbors, colleagues safe. So thank you, and I'm happy to turn it over to my colleagues. And I don't know if you want to take questions now or at the end. Perfect, thank you.
Good afternoon. I am Karen Herron. I'm the Executive Director of Marylanders to Prevent Gun Violence. I'm here in support of the Family and Law Enforcement Protection Act. At the federal level, 18 U.S.C. 922 G8 addresses firearm possession at the final protective order stage, but it does not apply at the temporary stage, and it provides no mechanism for prompt, verifiable relinquishment. This is a gap that states are expected to fill, and many states have long since done so by requiring firearm prohibitions at the temporary order stage when courts have already determined that there is a credible risk of harm. This is a time and court-tested approach that this bill then would adopt for Maryland. Current Maryland law recognizes that firearm prohibitions are appropriate in domestic violence protective order cases. However, courts are not required to impose those prohibitions at that temporary stage. This bill closes that gap by making firearm relinquishment mandatory at the temporary stage and by establishing a clear and enforceable process to ensure compliance. So the prohibition is not merely paper-based, but real, verifiable, and actionable if law enforcement must intervene. So practically, the bill does 5 things. It builds out the petition and court record to document firearm access, requires firearm prohibitions at the temporary stage, allows sworn attestations under penalty of perjury when a respondent claims they do not possess firearms, creates a record needed to support probable cause for a search warrant if a respondent fails to comply, and it makes compliance logistics clear to respondent. Finally, this is the product of more than 2 years of collaboration with stakeholders across the system, victim advocates, law enforcement, the judiciary, and others, because a workable process is what saves lives. We respectfully urge a favorable report. Thank you.
I found that impressive. Good afternoon. My name is Lori Ruth. I'm the Public Policy Director at the Maryland Network Against Domestic Violence. I want to thank Senator Hedelman, and I will also thank Delegate Bartlett. Over the interim, after last year's version of this bill, we did a lot of hard work at their direction and impetus to try and make this a stronger and more carefully crafted bill than last year. I just want to talk to you about the reality of domestic violence and firearms. You can Google Everytown for Gun Safety. They'll give you a one-pager on the absolutely irrefutable, undeniable link between domestic violence, homicide, and guns. And the most dangerous part for a victim is between when they get the temporary protective order and the final order. So that piece of making it mandatory at temporary is a life-saving portion of this bill that's really, really important. I have a lot of statistics. You know, Black women age 18 to 34 face significantly higher risks. They're 5 times more likely to be killed by a firearm in an abusive relationship compared to white women in the same age group. The number of female homicides by violent partners has accelerated escalated in recent years. From 2014 to 2023, there was a 22% increase in intimate partner homicides. However, it was driven by a 36% increase in the use of guns, whereas for all other ways of killing your partner, only increased by 3%. So guns are at the core of trying to save lives in this state. Every statistic will tell you that. Every research will tell you that if we can remove the guns, it's going to be safer for victims. So what this bill does is provide a mechanism for that to happen. And we've carefully looked at constitutionality and the ability of law enforcement. And we urge a favorable report for so many reasons. I just one last thing. I presented with my testimony the charts that the Maryland Network does, and you should look at them, because in 2024, the biggest commonality of the people who were killed by their intimate partner was they left the relationship. And that's that temporary protective order to final protective order and thereafter. Thank you very much.
Excellent. Thank you very much. All right, we'll switch over to questions. We'll start off with Senator Henson and then Senator West.
Thank you, Mr. Chairman. Thank you to the sponsor and the panelists for your testimony. When I'm not here, I'm an attorney. In a case I had recently, I represented a survivor, and we were there for a protective order hearing, and we worked out what we thought was a very good consent for a final protective order. The respondent was an active duty member of the military. A part of the order, we worked out custody, we worked out what would happen, but when we were in front of the judge and we were going through all the check boxes and the form, it gets to the part of the form that says surrendering your firearms. And of course, in the final protective order, it's a shall, not a may. And this bill would make the temporary a shall, not a may. And the judge says to the young man, "Sir, do you understand what that means in surrendering your firearms?" And he, realizes standing there at trial table what that means. And she says, "Being active duty military, if you were to comply with this, what would you have to do?" And he said, "Ma'am, I would have to leave here. I would have to report that to my commanding officer. That means I wouldn't be duty ready if I could not," because it doesn't just say own. The law says you can't own or possess. He says, so I couldn't use the training weapons, I couldn't use my service weapon, I wouldn't be eligible to deploy, I wouldn't be able to perform my job in the military if I was not able to possess a weapon, because that's what I do. And he said, "Is there any way that we could work around that?" She and we agree. I will not talk to her. I will not threaten to abuse or harass. I will not come to her job. I will not go to the school. I will pay the family maintenance. I will give her use and possession of the vehicle. But I can't do all of those things if I can't maintain my job as an active duty member of the military. And we didn't have flexibility on that provision. So the consent agreement that we worked out fell apart at the trial table, and it wound up being a trial on, the facts that made her eligible for relief and then all the factors for relief as a result of that. And I don't know what happened to that young man after he left the courthouse that day, because we wound up with the protective order. But understanding that the desire of the bill is to now make this a permanent feature at the temporary stage where you're there and it's an ex parte hearing and the other party isn't there and they don't get the opportunity to have that advisement and the notice and the understanding and kind of what that young man got there on that day. If we're looking at just the narrow subset of maybe active duty service members who need to possess a weapon, not for personal use, not to have at the home where their partner is, but to have as a feature and a function of their job, what's the position of the advocates and the bill sponsor about that very narrow instance that I found myself in as an attorney in the courtroom on that day?
Thank you for the question, Senator Henson. It's a conundrum, right? We're trying to balance perhaps the life of one person over the livelihood of the other person. And I will say, when I was practicing as an attorney doing protective order cases, oftentimes we would be confronted with this, and our own clients didn't want him to not be able to perform his job. And so there are mechanisms within the court system. It's not something we ever wanted to do or recommended, but if, we're victim-centered, so if this is what they wanted, we could enter into an agreement that was not a protective order so that mandatory surrender wasn't in effect. So essentially, you'd go into the custody and divorce or some sort of case like that and come to an agreement to all those other provisions and not address the gun. I don't like that personally, and I don't think advocates and lawyers who represent survivors do. But if you are victim-centered and that's what they want, that's what is an option for them. I will say this, a temporary protective order is, 7 days. We are going to have a bill that is going to try and lengthen that, but we're one of the states that is grossly behind other states in how long we have a temporary order for. And in the scheme of things, it is my view that it's better safe than sorry, and have that 7 or 14-day removal of the gun, and then come to the full hearing and have the full hearing to make the final decision about the surrender. And if the final protective order is granted, that's the decision of the court. And it's unfortunate. We see it not just with military, but with law enforcement. But they commit abuse as well. And there are consequences for this type of behavior. So I don't know if that satisfies you, but that's my view.
I appreciate it. I was curious what the perspective was for that, particular circumstance. It is narrow, but I appreciate your perspective. Thank you.
Thank you,
Mr. Chairman.
Thank you, Mr. Chair. So towards the end of session last year, we had a committee dinner, and I was presented with a mug. I think we all are presented with mugs, and which I use, by the way, nearly every day. And on the outside of the mug, it contains the words, "This bill is clearly unconstitutional." And that's because I believe that the oath I took when I became a state senator means that I cannot vote in favor of a bill which I believe is unconstitutional. I believe that would be a violation of my oath. So we have a fellow who frequently comes before us in these sorts of cases. His name is Mark Pennick. Today, I understand he was arguing in the U.S. Supreme Court, so he could not be here, but he did submit written testimony. So what I would like to do now is read a couple of excerpts of his testimony and ask the witnesses to respond to what he would have said if he had been able to be here. Now, probably the testimony was going to last more than 2 minutes, so I'm not sure he would have gotten to say the whole thing. So this is going to probably give him a longer opportunity to speak to us, because I'm going to read his words. And I would hope that a lawyer there who's conversant in constitutional issues is willing to respond. So here he goes. He says, the first issue is that this bill amends both Section 4504-1, interim protective orders, and Section 4505, temporary protective orders, to allow a seizure of firearms without any showing of probable cause. As amended, Section 4-504-1 authorizes the seizure of firearms via an interim protective order based on a finding that there are, quote, reasonable grounds, close quotes, to believe the respondent has abused a person eligible for relief. As amended, Section 4-505A authorizes a temporary protective order to seize firearms if a judge finds that there are, quote, reasonable grounds, close quotes, to believe that a person eligible for relief has been abused. By mandating seizures of personal property based solely on reasonable grounds, the amendments made by the bill violate the Fourth Amendment. The Fourth Amendment to the U.S. Constitution provides, and then he states the language of the Fourth Amendment, which I'm sure you're familiar with, so I won't read that. These constitutional provisions apply to any seizures of personal property, regardless of terminology. Turn the page. In United States versus Place, a 1983 Supreme Court decision, the Supreme Court held that quote, the court has viewed a seizure of personal property as per se unreasonable within the meaning of the Fourth Amendment unless it is accomplished pursuant to a judicial warrant issued upon probable cause, close quotes. A warrant based on probable cause is therefore indisputably required for the seizure of personal property, unless some recognized exception applies. And it concludes, this section, it doesn't conclude, it goes on and says, stated simply, reasonable grounds is not probable cause. In United States versus Carpenter, a 2018 decision of the court, the Supreme Court held that a court order failed to comply with the Fourth Amendment, where the statute under which the order issued only required reasonable grounds for believing the records were relevant and material to an ongoing investigation, a standard that the court ruled, quote, falls well short of the probable cause required for a warrant, close quotes. Likewise, the Maryland Supreme Court has repeatedly held that the term reasonable grounds means reasonable articulable suspicion and not preponderance of the evidence or probable cause. That was the case of Motor Vehicle Administration versus Shepard, a 2007 decision. The Attorney General of Maryland recently stated to the Maryland Supreme Court that reasonable grounds is a different, lesser standard than probable cause. So those are the key portions of his testimony with respect to the Fourth Amendment, and I wondered if somebody would care to respond to that.
Well, I'm going to let our lawyer up here respond, but I want to respond first.
Sure.
One is 13 states do this, so I want to make that clear.
Have they been challenged in the Supreme Court for doing this?
I don't know whether they've been challenged on this course, on this particular element, but the Supreme Court's 2024 decision in Rahimi upheld as constitutional, reinforcing that disarming individuals judicially found to pose a credible threat is consistent with the Second Amendment. So I would put that
I'm sorry, you're conflating or confusing. I was talking about the Fourth Amendment. The Rahimi case dealt with, I'm going to come to that in a minute, dealt with the Second Amendment.
Second Amendment.
Right.
Right.
So is there someone there who would like to respond to Mr. Pennick's Fourth Amendment concerns?
I don't want to be the lawyer on this, Senator. I profess no expertise in constitutional law. However, what the senator says is correct. It happens all the time. And in fact, it happens in Maryland now discretionarily if you're concerned about it happening at the temporary protective order stage. Fine. So I would have to do some research. Frankly, I just am not up to stuff right now constitutionally to have a full argument with you. I'd love to, but I would need to do a little bit of work. I agree that under Rahimi seems to be very clear that states can do what they have to protect somebody. And that, and you know, I would emphasize it is temporary. This is not even after the final protector order expires, you can get your guns back if you want, and there's a mechanism in this bill for them to do that. So this is a temporary removal in the emergent situation for the safety because of the risk the person causes. And other than that, I can't do a constitutional analysis for you on the Fourth Amendment right now. I apologize.
That's okay. So I wish someone there on the panel would go back and take a look at the Supreme Court's case, United States versus Carpenter, 585 U.S. 296, 2018 decision, where the court held that reasonable grounds, quote, falls well short of the required probable cause, close quotes.
I understand what they're saying.
So you assert that there are other cases which have held this as okay. I would like to have citations to those cases so I can compare them to the Supreme Court case.
So the one I would give you right now off the top of my head is Rahimi. The case before that was Bruin, which actually is more on your side of things, but Rahimi
those are Second Amendment cases.
Draw that back.
I'm talking about the Fourth Amendment.
I will look. I'm happy to do the research.
Great. Let me go on to the Second Amendment since you all have brought up both Bruin and Rahimi. So here's what Mr. Pennick had to say about the Second Amendment. The constitutionality of the firearms disqualifications imposed by these sections of your bill violates the right to keep and bear arms under the Second Amendment. He cites first the Bruin decision and then says it was construed and applied in United States versus Rahimi, 602 U.S. 680, 2024, case just decided 2 years ago. It says where any disqualification is unconstitutional unless relevantly similar or distinctly similar restrictions were imposed during the founding era of 1791. That's what the Supreme Court held through Bruin and Rahimi. These amendments to the family law article are thus much broader than the federal qualifications specified the federal qualification by 18 U.S.C. section 1922 G, et cetera, the portion of the federal code adjudicated in Rahimi. Section 1922G imposes a federal firearms disqualification on a person who is subject to a court order that includes a finding that such a person represents a credible threat to the physical safety of such intimate partner or child. Rahimi sustained that provision as historically justified. So again, the issue there is a credible threat to the physical safety of a person. And Mr. Penick goes on and says, none of the protective order provisions, including the sections amended by this bill, conditions the firearms disqualification on any such finding. After Rahimi, any disqualification imposed by a protective order that is not based on a finding that the respondent represents a credible threat to the physical safety is likely to fail. For example, in Range versus United States, the Third Circuit Court of case in 2024, the Third Circuit recently held post-Rahimi that the firearms disqualification involved on a non-violent misdemeanant was unconstitutional under Bruin and Rahimi. This bill, he goes on in his final paragraph in this area of his testimony, fails to meet that standard. Section 4-504A authorizes the issuance of a protective order, quote, under the circumstances specified in Section 4-5041A of the subtitle, and that section in turn incorporates the definitions set forth in Section 4-501B, which are broadly applicable. Section 4-501B1 defines abuse to include false imprisonment and revenge porn. For a child, the abuse is defined by cross-reference to the Family Law Article Section 5-701B1I as including the physical or mental injury of a child under circumstances. These definitions do not necessarily constitute a credible threat to the physical safety of any person. To survive a challenge under Rahimi, any firearms disqualification must be limited to circumstances in which a court has made a previous finding that the respondent poses a credible threat to the physical safety of the petitioner. So it's drawing distinction between a threat to the physical safety on the one hand and the things encompassed by this bill, which include false imprisonment, revenge porn, and mental injury.
So, Senator, I will try and give you a response without having anything in front of me about this. But sure. I read if that's Maryland shall issue, right? That's where Mr. Penick is from, right?
I think that's correct.
I read his opposition testimony from last year, and he mentioned some of the same things. So then I read a response, probably on Every Town or some other website, up to this argument about Rahimi that said, but bear in mind that even Justice Thomas said, however, and there's a whole paragraph about however that he's not quoting in his opposition. And I will find it for you.
Please do. I'd love to read it.
Make a list of the things I'm going to find for you, and I will do it. Right. The second thing I will say is when he's talking about you quoted 5701, in last year's testimony, he raised the case of, I think it's called CN versus RM from our Court of Special Appeal, Appellate Court of Maryland, and he says that that was simply a case of mental injury. But I read that case last night, and again, he leaves out some pretty pertinent information about that case, where the court found that after CPS made a report that the child was afraid his father was going to hurt him, he had a fear of imminent bodily harm, which is square in the protective order statute. And then he interviewed both children in chambers, the trial judge did, and he came out and said, this child has a fear. He didn't say imminent bodily harm, but he said something very, very similar to that, and found, so they didn't find, CN versus RN, they didn't grant a protective order based on mental injury, and which then requires the relinquishment of any guns, which is the point of this discussion, because in a final, it's mandatory right now, and hopefully will stay that way. But he leaves out some pertinent information in that case, and I'll get you a copy of that case as well, because I read it and I thought, quite frankly, it's a little hard for me to say negative things about a man who's not here to defend himself, but I thought it was a little disingenuous in the testimony. I'll put it that way.
I would love to take a look at the case. And if you give it to me, I'll read it carefully.
Yeah.
Thank you.
And I had a third point that I have forgotten, and
I've got a third question here, and then I'm done. Okay. The third question deals with the due process clause. Okay. So let me read the relevant portions. Then it's only 3 paragraphs, so it's not that long, of Mr. Pinnock's testimony on the due process clause. Here's what he says. The interim and temporary protective order provisions amended by this bill mandate the imposition of the firearms disqualification without so much as a hearing at which the respondent has an opportunity to be heard, including the right to cross-examine witnesses and present evidence. This bill thus further departs from the disqualification imposed by Section 922G8 because Section 922G8 conditions the disqualification upon a hearing at which the respondent has a full right to participate. Section 922G8A imposes such disqualification only after a hearing of which such person received actual notice and at which such person had an opportunity to participate. Ex parte hearings do not qualify. There is no such right to participate accorded by Section 4-504.1 of your bill or Section 4-505. He goes on, allowing the seizure of property and imposing a disqualification on a constitutional right, allowing the respondent due process is a fundamental violation of an individual's right to be heard under the Due Process Clause of the 14th Amendment. Lawful owners of firearms have a Second Amendment right to possess their firearms and may be deprived of that constitutional right only after receiving proper notice and an opportunity to be heard. He cites Cleveland versus Board of Education versus Loudermill, a 1985 Supreme Court decision, and another decision, Board of Regents versus Roth, dating from 1972. And because possession of firearms is constitutionally protected by the Second Amendment, that right to be heard must include more elaborate procedural rights, such as the rights to present evidence, to cross-examine adverse witnesses, and to be represented by counsel. Ex parte proceedings cannot be used to strip people of their constitutional right to keep and bear arms. His final paragraph. The procedures associated with Sections 4-504.1 and 4-505 proceedings come nowhere close to meeting these requirements. It is not until a final protective order proceeding under Section 4-506 do respondents have any right and opportunity to be heard, and even that provision does not purport to guarantee the right to cross-examine witnesses or submit evidence, and that post-deprivation hearing could come as much as 6 months after the entry of the temporary order. That delay is intolerable. The disqualifications imposed by this bill are after a hearing in which notice could have been provided and are thus not dependent on any need for quick action or any showing of impracticality. Okay. Would someone like to respond to that?
Sure. I want to make it clear we are not talking about the interim phase here, okay? We are only talking about temporary. We have an amendment to clarify that here. We are not talking about removal of firearms at the interim stage.
I'm sorry that I'm totally, because when I read the bill, I read it mostly as dealing with an ex parte hearing.
It is a temporary, ex parte, and I'm going to get to that. So, and we know that at a temporary hearing, the judge can remove, can order somebody to be removed from the household, can order temporary custody of a child, and can order that they refrain from contact, abuse, staying away from their place of employment, et cetera.
Let me interrupt for a second. We passed the red flag bill several years ago, which allows a court on an ex parte basis to require someone's guns to be removed from his possession. But the red flag bill specifically provided for a very rapid hearing at which that person would have the right to come into court and present full evidence with attorney and cross-examine witnesses.
So And generally, these are 7 days. If they're not 7 days, somebody's trying to evade service. If it's going on for 6 months, then my guess is somebody is really trying to evade the service, right, of the protection order. So those are 2 points, and we'll, clarify the interim and the amendments. The third point is that if a court is finding that there is enough risk to award child custody to somebody for 7 days, in my view, and I have to say, the North Carolina General Assembly said it when they passed this law, something quite similar to it, that is enough to require surrender of firearms. So if they're, right, I mean, you're talking about somebody's child, and if they're ordering temporary custody of a child, in my view, removing firearms doesn't even come close to that. I understand it's a protected constitutional right, but if there is that much risk to award temporary child custody, in my view, that there is that much danger to warrant the removal of a firearm.
Okay, I'm going to conclude. Let me just say I appreciate your answers to my questions. I'm sorry to hit you with these constitutional issues, probably unawares. The good thing is I'm sure Mr. Pennick will take a look at the video of today's proceedings, and if we should decide to work on this bill later on, I'm sure he'll be invited to join us, and he will be able to offer his own response to what you all have had to say. Thank you very much.
Thank you.
He's probably streaming it live from the Supreme Court. All right. Senator Fulton.
Thank you, Mr. Chair. I don't know who wants to come up, but whoever. Senator, I guess. Good to see you.
Good to
Thanks
see
for bringing the bill.
We can defer, but go ahead.
Okay, yeah, you can transfer it off. It doesn't matter. So I'm not going to read Mr. Pennick's 9-page thing here. I'm going to go very focused in the idea that the ex parte is Latin, and it's simple. It's very, very simple, and it means from one side. Yep. Only one person is getting to speak. So that in and of itself is a problem within the vein of how this bill is crafted to remove someone's Second Amendment protected right off of one person. Now, we have red flag laws. So the red flag laws are very, very scripted. And there's a very specific few who can actually petition to have that done on the basis of safety of the petitioner and or someone else or the firearm owner, correct? Mm-hmm. So when we don't have due process and we're looking at having someone off of their word, and I know you're going to find this hard to believe, but sometimes people aren't always truthful, go into a court, that creates a very big concern and ironically a red flag for me because we're looking, it's not just a small issue. And I mean, does that make sense at this point? I mean,
totally understand what you're saying. If you'll allow me, we've already crossed that bridge, right? So first of all, I do believe it's due process. I fundamentally believe in due process, especially in this day and age, and believe that we have already made that leap in our protection order process, right? So we have said an ex parte needs to come before a judge who hopefully has the experience to be able to judge credibility and evidence, and and has the opportunity to ask a whole series of questions about what the person is alleging, and comes to some determination about whether they believe they are being truthful. And then we have a 7-day period and an opportunity for both parties to present their.
You're correct, though. We already have a process under the ERPOs.
Well, yes.
We do.
And first of all, yes, we do.
We do.
And not enough people know about that process. This is far more accessible. We have over 21,000 people who have sought and gotten protection orders.
They can go and, maybe that's because we need to do a better job of, we were talking about education and training.
We do.
Of the clerks that come in, because that when people come in and discuss with the clerks, maybe the clerks aren't familiar even with an ARPO. So that's a training issue for those that are in those parts of our governmental responsibility as far as a measure for those citizens that may be impacted by this. However, the idea that I find it ironic that in today's society that there's so much federal fodder over due process we're looking at literally taking away a part of the due process for someone to have their firearms taken from them, albeit a temporary. But it's still an infringement on their constitutionally protected rights without having due process and without having probable cause. There's no level to probable cause in an ex parte, which is what the good senator was reciting from Mark Pennick. And then the last thing I'll close with is the idea that you made the comment about, I think it was South Carolina and the child custody.
North Carolina.
So just I want to be very clear on this as being someone that's been, helped people through these processes. Child custody is not relevant directly to firearm ownership or protections because child custody is generally awarded to the person that they leave in the home to minimize the disruption to the child. So I want to be very clear on that. That is a very constant pattern for the people that during an ex parte hearing, if they're going to have someone removed from the house and there's child custody, it's not merited basically only off of, well, does he have guns or does he not have guns? It's merited off of the least disruptive measures, generally speaking, to the child for their schooling, for whatever their daycare or otherwise, but there's no direct correlation between awarding a child versus firearms ownership.
No, I would argue that there's direct correlation with safety.
Well, I would argue, and my point would be, show me where that's a correlation of data that shows that it was awarded based off of firearm ownership.
No, that wasn't my point at all. That wasn't my point in saying that. I was not making the connection. I was just making an analogy where that we have a process in place and an ex parte process at that can award someone child custody, use of the home, can depose somebody from their home. And my only point in raising that analogy was that if we've gotten to the point where we would, looking at the full circumstance of the application for a protection order, and that there was enough danger and concern to award one parent or one person custody of a child, that those are alarm bells that I think would also warrant removal of firearm. I wasn't linking them in any way.
It appeared that you were to me,
no,
so I
not
apologize.
linking the kid with the firearm.
It is. You're acknowledging it's only a 7-day ex parte until a hearing is scheduled.
Yeah.
So awarding the child is usually centered around the least disruptive to the child and who stays in the home as it is. So, and I think that's a pretty consistent thing. And you all shaking your head. I don't know how many times you've been in court for these, but that would be something that is like. So so the child, if they're giving that specifically, I mean, it's normally, like I said, that's my experience. How's that? So thank you for your time.
Thank you.
All right. Seeing no further questions, thank you all very much. That'll conclude the testimony for the proponents of the bill. We now have Mr. Jocelyn in the Zoom room to provide opposition testimony. Mr. Jocelyn, you're up. Next. Welcome.
Thank you, Mr. Chairman. John Jocelyn speaking on behalf of 2A Maryland in opposition to Senate Bill 20. Senate Bill 20 is a journey through a minefield of constitutional conflicts. The journey will end with a boondoggle of logistical problems for enforcement for local law enforcement. The bill focuses on firearms. It requires tremendous reporting requirements, asking petitioners for information they may or may not have, and they must provide answers under oath. This bill could be counterproductive by reducing the number of people who'd be willing to file the petition. The bill does not address the overwhelming number of domestic assaults that do not involve a weapon of any type, and it totally ignores the weapons most often used in aggravated assaults. It naively presumes that the respondent will, in fact, obey the law. This will give the person a false sense of security when, in fact, they are not any safer, because it's certainly possible to do harm without the use of any weapon. The Uniform Crime Reports show this very clearly. The language of the bill conflicts with itself. It requires that the HQL and carry permit and firearms be turned in under a protective order, and that they be turned in again under a final order. Exactly how one gets all these things back to turn them in is just an interesting curiosity. For law enforcement, they do not know how many firearms the person owns. They don't know where they're located. They don't know who might have them. They would have to get search warrants because the petitioner has to list where they might be located, which may or may not be in the possession of the respondent. This is going to create a logistical nightmare for law enforcement, which is going to use too much time and will not make anyone any safer. We believe that this bill is not really useful for what the proponents believe it will do. We ask for an unfavorable report.
Thank you very much, Mr. Jocelyn. Questions from the committee? Senator Folden has a question for you.
Apologies, Mr. Chairman. I'm trying to navigate my screen here. Thank you for your testimony, Mr. Jocelyn. So I found it interesting that one of the points that they brought forward was about the every town mentioning about 5 times, the claims being made about 5 times through every town. And to your knowledge, is any of this documented through any UCR data?
The UCR reports, they don't give that sort of a comparison. You have to understand that every town is a special interest group and their data is going to reflect their position. I use the Maryland UCRs because it's unimpeachable data. It's provided by the state and the data is what it is. I can tell you that from 2020 to 2024, there were 138,271 domestic cases. 19%, or 26,120, were aggravated. 45% of those involved no weapon whatsoever. 27% were other weapons. 18% were knives, and 11% were firearms. So no weapons were involved in 4 times the number of cases where firearms were involved. It is not the quote-unquote weapon of choice.
Okay, and you've heard us talk about the constitutionality and meeting the threshold of probable cause. I mean, I think it's pretty clear even in their own statement that it doesn't meet the rise of probable cause because it's only one-sided statement. Would you agree with that?
I would agree with that, and I would go on to add that for law enforcement to do a search of someone else's property, they would have to have probable cause. And I think they would be very reluctant to go to a judge and ask for a search warrant because the person who's the plaintiff says Tom, Dick, and Harry might have Joe's firearms. I seriously doubt that they would get a warrant for that effect. And if they did, once they arrived at Tom, Dick, and Harry, if they found firearms that were there that belonged to those people, how do they differentiate what belongs to the respondent and what belongs to the homeowner that they just did the search warrant on? I think we'll end up having law enforcement being in court defending seizure of firearms that belong to someone else.
That's a good point. Okay, thank you. I appreciate your time.
Thank you, Mr. Chair. Good afternoon, Mr. Jocelyn. 2A is an interest group also, correct?
That is correct.
Okay. One of your arguments against this bill is that the respondents will not follow the law. Did I hear that correctly?
What I'm saying is that bill depends upon the respondent following the law.
So,
and if this person is in fact the type of personality who would do harm to someone else, they certainly are not going to be terribly intimidated by breaking one more law.
So is it your contention?
It gives a false sense of security.
So is it your contention then we should never, excuse me, sir, is it your contention then that because respondents won't follow the law, we should not pass laws for safety?
Oh, absolutely not. I'm just saying from a practical standpoint, when the whole crux of the matter depends upon the person being law-abiding, you have a fatal flaw in the structure of the bill.
Interesting. Thank you.
All right. Further questions from the committee? Seeing no further questions, thank you very much, Mr. Jocelyn. With that, that'll conclude the hearing and the testimony for Senate Bill 20. Thank you very much, Senator Hedelman. All right. We'll now move on to Senator Carrozza. Thank you for your patience, Senator, with Senate Bill 222.
Good afternoon, Mr. Chair Vice Chair Waldstreicher, and members of the esteemed Judicial Proceedings Committee. For the record, my name is Mary Beth Carrozza, proud senator of Maryland's Coast, Worcester, Wycomico, and Somerset counties. And I am here to present this bill, Senate Bill 222, Child Custody Evaluators, Qualifications, for the 6th consecutive session, and to respectfully urge a favorable report for this priority child protection legislation. I would like to thank the chair, Vice Chair Waldstreicher, and Senator West. Senator West has been a co-sponsor for the legislation the past sessions, as well as Vice Chair Waldstreicher. And Mr. Chair, I'd like to thank you for meeting with me over the interim to talk about where we are with the bill. I am presenting this bill on behalf of the many Maryland families, children, and child safety advocates who remain committed to passage of legislation ensuring qualified and trained child custody evaluators whose recommendations impact the placement of children, many of whom have already experienced trauma and should be protected. And I especially want to thank the founder of Child Justice, Eileen King, for being here today and for testifying. For the past 5 sessions, we have been working in good faith with you to move this child protection bill forward for final passage. So what makes this year different? And this is what I'm happy to share with you. First, a bipartisan working group from both chambers increased efforts and coordination and shared amendments and updates with the judiciary as we worked for passage last session. Senate Bill 222 has been reworked since its first introduction, and the judiciary has acknowledged the value of the bill by updating Maryland Rule 9-205.3 based on many of the provisions from this legislation. Senate Bill 222 codifies the judiciary's updated rule, which went into effect October 1st of 2025. It does not dictate how the training is to be done. Further, it is significant that Maryland was the first state to pass legislation, Senate Bill 17, sponsored by Senator Chris West, requiring the training of judges presiding over child custody cases involving child abuse and domestic violence back in 2022. But since then, 5 other states, including California, Pennsylvania, Utah, Tennessee, and Colorado, have passed training bills for all court professionals involved in court custody proceedings, including child custody evaluators. So I'm sharing with you, and I hope you will agree, that it only makes sense for Maryland to put child custody evaluators training into statute, as was done with the judges training bill back in 2022, and that 5 other states have already done so. I'd like to just briefly share, for those members who may not recall this as way of background, this bill goes back to and was developed out of work and recommendations from the work group to study child custody court proceedings involving child abuse or domestic violence allegations. And that was a work group that was chaired by former Maryland Secretary of State John Woban-Smith, and former Senator and your former colleague on the committee, Susan Lee, and I also served on the work group. Fast forward, in 2022, this committee and the Maryland General Assembly approved Senate Bill 17, as noted, which requires the training of judges presiding over child custody cases involving child abuse and domestic violence. Child custody evaluators should meet certain qualifications and be trained along the same lines as the judges, especially given the heavy reliance of judges on the recommendations of child custody evaluators. And over the past couple years, Mr. Chair, and this is what I wanted to share, coming back again, we have been working with the judiciary. We have made significant progress updating and revising the bill, which reflects the recently updated judiciary rule that just went into effect. And again, that bipartisan group included Senator West, Delegate Crutchfield, Delegate Kaufman, and we also met with Judge Dumais, representing the Maryland Judiciary, to work together on updating and strengthening that rule. And we are grateful for Judge Dumais' leadership and her work to update that rule. And Senate Bill 222 before you today reflects the updated judiciary rule, which just went into effect in October. I do want to point out, again, working through some of the issues of what's different from last year and this year, that the rule that was just updated, NSB 22, includes 2 amendments agreed upon last session to specify that custody evaluators should have demonstrated knowledge of child sexual abuse and disability-related issues. I also want to point out that the legislation includes an amendment recommended by the judiciary that the court may waive the requirements for a court employee or an individual under contract with the court who conducted custody evaluations for at least 14 years prior to January 1, 2025, completed a training program, and completes at least 20 years per year of training. So the issue comes down to the question that's been raised in the past on whether the child custody evaluator qualifications and training requirements should be in a rule or in statute. The logical response is it can and should be in both. Impacted families and child protection advocates have been demanding that these qualifications and training requirements for child custody evaluators be put into law, just as the judge's training bill was put into law in 2022. Additionally, while Maryland recognizes that the rule shall have the force of law without actually being law, it is unclear whether the federal government would share that recognition, and therefore any federal funding through Caden's law or other federal statutes could be in jeopardy and not available to the state of Maryland without passage of Senate Bill 222. Senate Bill 222 is a child protection bill. And putting in statute that Maryland's child custody evaluators will be qualified and trained helps protect children in those most sensitive and potentially dangerous child custody cases involving child abuse and domestic violence. And I contend, Mr. Chair, and to the members, I believe it also builds goodwill and trust with the judiciary. When we think about the many qualifications and training bills that the Maryland General Assembly has passed into law over the years that impact positions not dealing with our most precious responsibility, our children, I believe we as legislators have a moral obligation to pass the Child Custody Evaluators Qualifications and Training Bill this session and ensure that it becomes law this year. And Mr. Chair, I know that you have had past conversations and we've had a past witness that could not be with us today, Hara McLeod, author, speaker, civil rights activist. And her story firmly shows why consistent qualifications and training for child custody evaluators are desperately needed. Hara was a protective parent from Montgomery County who separated from her child's father on July 17, 2011, case number Family Law 96093. The child custody evaluator assigned to her case understood that the father, Jacqueline Rams, was dangerous to Hara and her son Prince based on evidence presented by several witnesses in Rams' life who believed he routinely abused his older son and that he had already killed 2 people. Unfortunately, Rams' attorney was able to have the child custody evaluator's testimony disregarded due to the lack of training and credentials of the child custody evaluator. In October of 2012, Prince was murdered by his father when he was 15 months old. In the opinion of Paul Griffin, Child Justice Legal Director, if child custody evaluators were required to have qualifications and training, Hara's case most likely would have had a different outcome and Prince would be alive today, and I agree. I also wanted to share with you a letter from a 16-year-old teen, which also shows why this is an important child protection bill. And she writes in her letter, that for half of my life, I have had to deal with these failed and faulty opinions of people who were untrained and barely talked to me. I would never want another child to experience what I did. Please help the future children of Maryland. Mr. Chair, Mr. Vice Chair, all the committee members, it is time to pass Senate Bill 222 and to put into law and to ensure that the child custody evaluators meet these qualifications and training requirements to better protect our children. We should do this for the Maryland families, children, and child safety advocates who have been appealing to us. And I ask for a favorable report on Senate Bill 222. Thank you very much.
Good afternoon, everyone. My name is Eileen King, and I am so appreciative of being able to testify today on Senate Bill 222. And I thank Chairman Smith, Vice Chair Waldstreicher, members of the committee for hearing what I have to say here. I'm the founder, executive director of Child Justice, and I've been doing this work for over 30 years. And when I hear about Hera McLeod, I will just never forget that moment when I got the call from her in August of 2012, where she said to me, "I know he's going to kill my son." This is what we live with when we're doing this work. We're called child justice, but we're really about child protection. And I'm so grateful for Senator Carrozza laying out in such wonderful detail the reasons why this bill is so essential. And one of the reasons that I'm going to make my testimony pretty short is that I have a slogan: when we know better, we do better. When custody evaluators know better, they will do better. This is a public safety issue. It's a child safety issue. And I've seen so many cases. I've been court watching for years and years. The first case I saw was on 2002. It was the anniversary of 9/11. I was there with a protective father who himself was a fireman who helped put out the Pentagon roof fire. He was trying to protect his son in a child sexual abuse case where the mother had married the alleged abuser. This child disclosed and was not believed by the Maryland-based evaluator. The father said, "I've trained to do these horrible, difficult things, but I'm not trained. I don't know how to protect my child." We urge a favorable report, not just because Child Justice thinks so, but it's your constituents, your voters, the people who depend on you all to do the right thing. Thank you.
Thank you both very much for your testimony. We'll now turn it over to the committee for questions. Senator West.
Thank you, Mr. Chair. I just want to say that 4 years ago, when I introduced the bill, I think it was 4 years ago, to require judges who are going to sit in child custody cases to receive training, the issues that they would be encountering, I made a mistake. I should have worded that bill to require not only the judges, but also the custody evaluators whose opinions and recommendations the judges would be relying on to get the same training. I didn't do that 4 years ago, and that's why we're here with this bill today. This bill corrects the mistake that I made 4 years ago. It requires not only the judges to get the training, but the custody evaluators, upon whose recommendations the judges are going to act to get the same training. I think this bill makes every bit of sense, and I guess I should end with a question. Isn't that so? Thank you. Thank you.
No, so Senator West, thank you as well for your work, and I know, I mean, and especially Hera, because she's done phenomenal work in just unimaginable circumstances, and our kids go to school together. I see her frequently, so I have the utmost respect for her, and I will call her probably tomorrow at some point to ask her opinion on this latest iteration of the bill. My question, though, is, sometimes the specter of legislation can create change through the Rules Committee, And absent the normal separation of powers arguments that the judiciary will always make under these circumstances, my question is, I mean, to you as well, Senator West, you know, if the rule right now is meeting the mail, mirrors or mimics the statute that you're proposing right now, and maybe is even more comprehensive, I don't know, is the rule not more preferable because there is flexibility that can flex and change where standards and norms and qualifications change and new information becomes available, that the rule could flex to adjust to the latest and greatest information for training, whereas a statute, we'd have to come back here and do this whole rigmarole again? Or, you know, is the force of this is an open question. I'm not kind of slanted on one side or the other. I'd like to hear from both. But we'll go to Senator Croza first and then Senator West.
Thank you. That's why I wanted to be very clear that the bill does not dictate the training. But when it comes to our constituents, the Maryland families, the children, and the child safety advocates, it's imperative that it's put into statute, just like 5 other states have already done so.
Thank you for the question. It's a good one. My feeling is going down the road, the training for the judges and for the custody evaluators should be consistent. So we have currently in statute the requirements for the judges. We ought to have the same requirements in statute for the, and if we're going to make a change, we should make a change to a statute which would change both simultaneously, rather than have a rule adopted in between sessions, which would then adopt inconsistent standards for one or the other.
No, I appreciate that. Thanks. Any further questions? All right, with that, Senator Croza, thank you very much, and thank you for your time this summer as well. So we'll follow up. And Ms. King, good to see you as well. All right, with that, that'll end the hearing for Senate Bill 222. We'll now move on to Vice Chair Wallstreicher with Senate Bill 155.
While my witnesses are coming up, Mr. Chair, I'll mention yesterday, it was so cold in my office, literally so cold, that I ordered a space heater, which apparently I don't need today.
It's burning up in here right now.
Because it's quite the opposite.
I thought you were going to talk about those heated vests.
Oh, that's right. Mr. Chairman, members of the committee, last year we definitively rejected a bill that would have allowed bicyclists to proceed on a stop sign utilizing a yield instead of a stop. And there were some safety reasons why that bill was advocated for, but my sense is this committee felt that that bill promoted kind of a sense of rules breaking, or at least a perception among drivers that bicyclists didn't need to follow the rules. So even as I disagree with it, I'm empathetic with why this committee decided to do what they did. But the House last year passed a separate bill, a different bill, that I think more reflects our values, that requires everyone to follow the rules and be orderly on the road while still providing a sense of safety for bicyclists on the road. And so here's what the bill in front of you does. When we were all growing up, everyone got a green light together. So the light turned green and the walk light for pedestrians turned white, and everyone went simultaneously. But over the past decade, I don't know if you've noticed this, the walk light will turn white first before the adjoining green light turns green. And traffic engineers use this very kind of jargonistic phrase. They call them LPIs, leading pedestrian intervals. But basically what it does is it allows pedestrians to start before cars start, and their presence in the intersection, literally 1 or 2 seconds before the cars get the green light, provides a sense to the cars that there are other people around them that they should take care of. But it's a little unclear how bicyclists are supposed to treat leading pedestrian intervals. Do they wait for when the cars go, or are they allowed to proceed when the pedestrians go about 1 or 2 seconds before the cars go? Well, some states have experimented with this. 2 states have passed it, as has New York City. They allow the bicyclists to proceed on the white walk light instead of waiting for the green light that applies to vehicles. And the results have been pretty amazing. In New York City, which I get is more urban than some of the areas that we represent, but in New York City, crashes between bicyclists and cars are down 40% since they allowed bicyclists to proceed on the pedestrian walk light. And so that's what this bill does. It simply allows bicyclists to go with the pedestrian walk light when the pedestrian walk light is flashing white. And so it doesn't allow anyone to break the rules or bend the rules or rules that are specific only to bicyclists. It just makes clear that when there is a leading pedestrian interval, and in some places there are not, in more rural areas there are not, bicyclists can take advantage of that interval so that cars know where they are. With that, I'll defer to my advocates and ask for a favorable report.
Thank you. Good afternoon, Chair Smith and members of the committee. My name is Haley Peckett. I'm the Deputy Director for Policy and Planning at Montgomery County DOT, and I'm here to request your favorable report on SB 155. This bill, as Senator Waldstreicher talked about, has a lot of benefits, but I want to really emphasize that it's giving greater visibility and safety to cyclists without taking away from the safety of any other roadway users or changing the efficiency of the signal operations. We're not adding delay to the road. We're not adding time for cars to sit and wait. Senator Waldstreicher talked about what an LPI is, and so I'm not going to repeat that, but I'm going to note that there's no requirement for anybody to install LPIs. This simply confers the benefit that we currently give to pedestrians to cyclists on areas that we already have LPIs. So speaking from Montgomery County, we, as part of our own local Vision Zero legislation, installed over 200 LPIs at over 200 intersections just in the past 2 years. And so at those intersections, pedestrians are able to be visible and safer in the intersection because they are visible when cars are making the right turn. Currently, that benefit does not exist for cyclists, and I know personally when I cycle, and especially when I'm cycling with my children who might be slower to get a start, that extra few seconds establishes us in the intersection and makes it really clear to cars not to turn right into us and to go ahead and wait that extra 2 seconds. I want to also note that there's no cost to taxpayers to do this. The benefit just is conferred where LPIs already exist, and there's no need for additional signage. I want to emphasize that other areas that have enacted this legislation have seen safety benefits, including a much lower occurrence of serious injuries or deaths. So I encourage us as a Vision Zero state to pass this legislation, and I request your favorable report on this bill.
Good afternoon. My name is Joshua Feldmark. I'm here on behalf of Bike Maryland, and for those of you who know what I do for a living, I should be very clear that I'm here on personal and not professional basis. I won't belabor the point. Instead, what I'll do is maybe paint a picture for you. You're in your car, you pull up to an intersection, there is in front of you is a cyclist of my density, let's say, and you can either, when the walk sign turns, get me a head start, and so I can get out of your way faster, or you can I have to wait for the green light, in which case it's going to take me a minute, maybe more, to get myself up and moving. And so for everybody's convenience and everybody's safety, when pedestrians get a head start, if you give that to cyclists, it works to the benefit of everybody in the intersection. With that, I urge a favorable report.
Thank you, and thank you, Senator Waldstreicher, for going back and really being creative and coming up with an interesting and wonderful solution, I think. So the only thing I had was, both of you could answer, I guess I'm wondering about how we can, without spending money, educate the public, because especially in non-Montgomery counties, this will be very new, very not known. I don't know if Montgomery engaged in its own efforts to just let the public know, because some drivers may go, hey, why are are those bicyclists jumping out of the gate? but I also don't want to waylay the bill because I think it's a wonderful solution. What would your thoughts be, and how could we just get the word out without, I'd like it to be the Department of Transportation and not the counties, but what are your thoughts there?
Yeah, that's a great question. So I will, to some degree, speak for Montgomery County, but I think you're actually asking for other counties. So there's actually a number of federal programs that specifically talk about safety. So there's Safe Routes to School program, there's transportation alternatives programs. So most jurisdictions are getting funding to some level through that, through their MPOs. And so as part of that, there's already outreach and already relationships with a number of these individuals, but working through trusted community groups, schools, et cetera, is a great way to get the word out.
Wonderful. Thank you. That's it.
Thank you, Mr. Chair. I couldn't understand the bill when I read it. I now understand it once it's been explained. But you have this language that says, unless otherwise directed by a traffic control device. What are we talking? What kind of traffic? What at an intersection would you have some kind of a
So there
special light?
are, in certain jurisdictions, there are separate bike, there's the green light, a traffic light for cars, there's one for pedestrians, and there's one for bikes.
Really? I've never seen that.
Yeah, they're pretty common in DC. There's not a ton of them in Maryland yet, but yeah, that's what it's referring to.
Okay, thank you. That explains that.
Mr. Feldmark, good afternoon. I was, in listening to your description, I'm curious. You're not getting that head start based off of the traffic signal. You're getting it based off of the walk.
Correct.
All right. So as soon as that turns to the walk, the bicyclists can go.
That's right.
Okay.
Right. That's the entirety of this bill, is whether or not the cyclists in these indications where the walk sign goes before the green light for the car, that whether or not the bikes go with the walk sign or they go with the green light. And this is saying that switch it to the walk sign.
And I'm assuming if a pedestrian is walking along and maybe the bicyclist has to make a right turn, they still have to wait for the.
Oh yeah, absolutely, absolutely.
Thank you.
Question for Senator, please. So what's the problem we're trying to fix? So are we having police officers stop bicyclists who are going through the green light? Are we having, I'm going to pick on my community because it's more of an elderly community, raising their cane at somebody taking off?
So we're trying to solve for two problems. The first problem we're trying to solve for is basic safety, right? We have too many accidents between bicycles and vehicles, especially when the vehicle is turning right.
Okay.
The second problem we're trying to solve for is a JPR problem, where last year we specifically rejected a mechanism by which bicyclists could essentially have special treatment and utilize a stop sign in a way that is different than a car. And I get that we're dealing with two different issues, stop signs and stop lights. So what I'm solving for is, how do we address the issue with the bill that we heard last year, the Idaho Stop Bill, while solving for the philosophical issue that we were trying to deal with last year, which is to not provide anyone with treatment different than anyone else. And so here we are treating the bicycles in the same legal capacity in which we are treating the pedestrians.
Right, but we have these signs all over our roadways that say share the road. So bicyclists are supposed to share the road. It doesn't say pedestrians share the road. It says, so I understand you're trying to solve something, but the issue really isn't, the problem isn't automobiles and pedestrians. It's automobiles and bicyclists. And we've already, I do believe we did pass of allowing bicyclists on sidewalks, which I was adamantly against because there again, for X amount of years that we've had it, you weren't allowed to do that. And now we made it a opposite. So I'm actually having, like, the city of Cumberland have to go through the process of having a hearing and explain that, and then explain, well, we know we did it for all those years, but now we're going to do it this way. I apologize for going on a rabbit trail there. But if the issue is automobiles and cyclists, the same conundrum that we have in JPR still exists, because this bill is saying we're going to treat bicyclists the same as pedestrians.
Yeah, that's correct. But it doesn't mean we're treating them as pedestrians in every circumstances. It just means in this specific circumstance, at the intersection, at the time the light changes, we are treating them.
So if we have somebody, we pass this law, and that cyclist can go forward, and there happened to have been somebody who then turned right, are we saying that then the person in the automobile is going to be the one who's going to be at fault?
Well, so that would already be the case under current law.
Okay.
And this doesn't change that.
So then I go back to why are we have this bill if we're not going to try to correct the safety of the bicyclists if someone turning into a right-hand turn to hit them? If that's already current law, then why do we have this bill?
Okay, so let me take a kind of a step back to answer your question and tell me if I'm hitting what you're asking for. There are two ways to create more safety on our roads. One way is to encourage people to follow current law and just be safer and more thoughtful about how they drive. And obviously, if everyone were doing that, we would have fewer accidents. Another way to create more safety in our roads is to create different structural norms which encourage people to be more thoughtful than they are currently being. And that's what we do all the time in the legislature. And so we have seen by placing pedestrians in an intersection earlier than vehicles, we actually create more safety, even though that's a little bit kind of counterintuitive. That's what we have seen in other states that have passed this law, is that providing that same benefit to bicyclists also increases their safety. So if you're saying, why don't we just, tell people to be better, I'm all for that. But if there are some kind of unique or creative ways by which we essentially force people to be better, then we should take advantage of those opportunities.
And I agree with you, but my only pushback, I guess, would be that we have created so much signage in our roadways. We have made it very, very confusing for people to be drivers to know where they're supposed to be, where the bicyclist is supposed to be. We've talked about there are a couple of options where there's actually lights for the differences, okay? We actually had a bill earlier on heard in this committee that resulted in somebody who was driving slower because they went through the signage and thought maybe that was the right place, of confusion about what is supposed to happen. I'm looking at it as the unintended consequences of creating confusion for our elderly drivers who are prevalent in the areas that I represent. So
I hear you.
Maybe we could talk about that
Yes.
offline, sir.
You'll be shocked at how much I agree with you. I'm in Senator Love's district when I drop my kids or pick them up at high school, and there's a bike lane in Senator Love's district where every day I feel like I may knock someone off. She knows exactly what I'm talking about because you can't see and it's a whole thing. But yes, I agree with everything you're saying.
Okay, thank you very much.
Thank you.
All right, that concludes this hearing, and I'll be heading up to the front. And Senator, no, I have the next bill, so you'll have to come sit up here.
Senate Bill 110. Do you want to announce what bill number it is for the
Yep.
record?
For the record, the next bill, Senate Bill 110, Senator Nick Charles.
You are so handsome, intelligent.
I have my own theme music, and I truly appreciate it. Thank you, colleagues. For the record, good afternoon, Vice Chair Wall Striker, and to the honorable members of the Judicial Proceedings Committee. For the record, I'm Senator Nick Charles, representing District 25, and I am testifying in strong support of Senate Bill 110. This legislation was previously introduced during the 2025 session as Senate Bill 565, where it was heard in this committee but did not receive a vote. We are reintroducing it this year to continue advancing the critical public safety reform. Senate Bill 110, also known as Mateo's Law, requires any driver involved in a motor vehicle crash resulting in the death or life-threatening injury to submit to both breath and blood testing for impairment. It amends Section 16-205 of the Transportation Article to eliminate the current discretionary standard and instead mandate testing in these most serious crashes, ensuring that alcohol and drug-related impairment is accurately and consistently identified. Under current Maryland law, chemical testing is only required if an officer determines that reasonable grounds for impairment exists. Only if an officer determines that. This creates inconsistency. It leaves gaps in accountability and can prevent a full and fair investigation of fatal and life-threatening crashes. This bill closes that loophole by requiring immediate testing. Immediate. We need immediate testing whenever a crash results in death or life-threatening injury. And why? Because it provides clarity for law enforcement, provides clarity for prosecutors, provides clarity for our courts, and it ensures that no impaired driver escapes detection due to procedural limitations. I got some mail a couple of years ago, and it was from Mateo Isaiah Green's mother, Miss Sherelle Green, who is sitting next to me. She lost her son, tragically lost her son in a fatal crash in April 2024. And his death, it highlights the reality that Maryland does not currently require mandatory testing of surviving drivers in fatal crashes. And this leaves critical questions unanswered. The questions that she's been trying to answer, the questions that she brought to us. And so we move forward with this bill to try to get those questions so no other family ever has to go through unquestionable nights ever again. This requires mandatory testing of surviving drivers. Now, the data underscores the urgency. According to Maryland Department of Transportation, from 2018 to 2022, more than 880 people were killed in crashes involving alcohol-impaired drivers in Maryland. Drug-impaired driving is also rising and cannot always be detected through breath testing alone. So requiring both breath and blood samples ensures accurate detection of alcohol, drugs, or a combination of substances. Now, states with mandatory testing laws demonstrate significantly higher testing rates and improve safety outcomes. The National Highway Traffic Safety Administration has found that states with mandatory chemical testing and per se enforcement laws experience up to 20% reduction in alcohol-related traffic fatalities after implementation. compared to states without uniform testing requirements. And then Insurance Institute of Highway Safety finds that jurisdictions with near universal BAC testing and fatal crashes achieve testing rates above 90%, which allow law enforcement to identify impaired driving patterns, target enforcement, and deploy prevention strategies that are directly linked to reductions and repeat offenses and alcohol-related deaths. This bill is measured, this bill is constitutional, and it's necessary, a very, very necessary step to strengthen impaired driving enforcement, honor victims like Mateo Isaiah Green, and ensure justice for families like his mother that's sitting here with me today, and provide consistency, transparency, and accountability in the most serious crashes, and brings Maryland in line with best practices nationwide. Now, Mateo Isaiah Green, I want you to remember that name. He was a son. He was a grandson. He was a younger brother. He was a nephew. He was a cousin. He was a friend. And he was one of us. He was a Marylander who deserves so much more. So for these reasons, I respectfully urge the committee to issue a favorable report on this bill, Senate Bill 110. And I want to thank you all. We've been here for quite some time today so far, but I want to thank you all for taking your time and consideration. Today on my panel, I have Ms. Sherelle Green, the mother of Mateo, and I also have Ms. Brianna Clark Braveman, the Mid-Atlantic Region Executive Director for Moms Against Drunk Driving, and they're both here to testify on this bill. If you have any other questions, I will be here at the table. Ms. Green.
Good afternoon. To the committee chair members, thank you for allowing me the opportunity to share my testimony today. As the senator stated, my name is Sherelle Green, and I'm the mom of Mateo Green. I'm also a lifelong resident of Maryland, and I'm now an advocate for justice and safer roads. I'm here today in strong support of SB 110, Mateo's Law, legislation that is a vital step toward ensuring that tragedies like the one that took my son and forever changed my life becomes the catalyst for a safer Maryland. On April 6, 2024, my son was one of 3 passengers in a single vehicle crash caused by an impaired driver whose blood alcohol content was twice the legal limit. No sobriety or impaired testing was administered at the scene. My son was pronounced brain dead on April 7th, just 15 days after his 23rd birthday. And he was the only fatality in this crash. I believe that the failure to conduct on-the-scene impairment testing delayed justice and compounded our grief. Nearly a year later, the driver ultimately received an 18-month incarceration out of impossible 10 years. 18 months for taking my son's life and seriously injuring the lives of 2 others. That outcome was shockingly painful and inadequate given the irresponsible harm caused to our family. Mateo's Law would require mandatory on-the-scene impairment testing for any driver involved in a crash resulting in death or serious bodily injury. Justice should never depend on the discretion of a responding officer or the subjective judgment of an EMT. This bill ensures timely evidence collection, accountability, and fairness while protecting the rights of both victims and drivers. Can I continue? I'm sorry. Okay, he said okay. From 2019, the year my son graduated high school, to 2023, there were an average of 142 impaired drivers in fatal crashes in Maryland. These are not just statistics. They are our sons, our daughters, our parents, our friends. Later this year, the statistics for 2024 will be released, and my son will be a part of those statistics. Mateo's Law is a necessary step toward preventing these losses and restoring public confidence in our justice system. I have forgiven the driver in my son's case. He was released on Christmas Day. And while forgiveness is a part of my healing, it does not erase the pain of living without my son. And while his offender returned home with his family, my family is learning how to survive our new normal without Mateo. In closing, as you consider your vote, I ask that you take a moment to reflect on how a tragedy like this would affect your own family or someone you love. None of us expect to face these traumatic moments, but thoughtful laws can help ensure that when the unthinkable happens, families are met with fairness, care, and accountability. Mateo's Law is about closing gaps, strengthening trust, and protecting families across Maryland. I respectfully ask for your strong support to advance Mateo's Law so that no other family has to endure delayed justice, inadequate accountability, or the 100% preventable loss of a loved one. Thank you for your
Thank you, Ms.
time.
Green.
Thank you, Mr. Chairman and members of the committee, for allowing me the opportunity to testify today in support of Senate Bill 110, as known as Mateo's Law, to help stop impaired driving. My name is Bryna Clark Braverman, and I'm the Regional Executive Director for the MAD Mid-Atlantic chapter. MAD thanks Senator Charles for introducing this proposal. For anyone who has not been impacted by a violent crash caused by an impaired driver, it may be surprising to learn that every day in the United States, 37 people are killed and more than 1,000 people are injured in a drunk driving crash. That does not consider the horrific crashes caused by other drugs such as cannabis or opioids. Since 2019, according to the National Highway Traffic Safety Administration, NHTSA, drunk driving deaths have increased 4%, resulting in 173 preventable deaths in 2023 in Maryland alone. Maryland is not alone in the historic increase in drunk driving deaths. Throughout the nation, drunk driving deaths are at a historic high. Lawmakers must do more. I am urging you to support SB 110. Mateo's Law, which requires anyone involved in a crash that results in death or life-threatening injury to submit to breath and blood testing for impaired driving. After a serious crash, time matters. Evidence of impairment fades quickly. And without immediate testing, the truth about what happened can be lost forever. Families are then left not only with unimaginable grief, but unanswered questions, wondering whether the crash could have been prevented. Mateo's Law will ensure that drunk drivers who cause a fatality or serious injury are properly screened for impairment for substances and other than alcohol. Mateo's Law, SB 110, is a victim-driven proposal that would allow for more justice, more accountability by helping law enforcement determine the facts about whether impairment played a role in a crash, and protects Marylanders by strengthening our ability to hold impaired drivers accountable. Mr. Chairman and members of this committee, thank you for allowing me to testify today on behalf of Mothers Against Drunk Driving.
Thank you so much. We'll now move to questions. Senator James.
Thank you, Mr. Chairman, and thank you, Senator Charles, very much for bringing this bill. And to the mothers of, I've lost a child, adult child, and you never get over it, and your bravery in being able to talk about it is very, very much appreciated. Senator Charles, I may have missed this. Your testimony was excellent, but did you, I know you have introduced the bill before. What happened? Why was it not passed? Was there a reason, or did we run out of time? Can you just remind me of that? If you spoke to it, I apologize.
We probably ran out of time.
Okay.
I know we brought this bill forward last year, and obviously a lot of us, we bring a lot of bills in, and we got to get through so much. So we're hoping and we're hopeful.
So we didn't get, I didn't see any overwhelming opposition. There may be some amendments, but I didn't see any strong opposition. So that wasn't the reason. No. Last year. Okay. So what I'm trying to figure out, because I am very alarmed that we, allow for recreational marijuana without adequate testing, right? We have a real problem with that, right? And people are going to get hurt. And they already are and are showing up in emergency rooms. So and I think we could have good testing for alcohol and probably pretty good testing for opioids and probably amphetamines. But marijuana is tricky, right? Because it can stay in your blood system a long time. And I don't know what the science says about your impairment 3 or 4 days later. I think most people would say you're not impaired. It just lingers in your system like a lot of other things that embed in your body, fat, which I think was one of the places marijuana embeds for a while. So how are we going, and we could take a blood test, right? And it would show THC or whatever. But the question then is, I don't think we have and we should have done this before we passed any recreational use, a standard by which we would say that someone is impaired under the chemicals that come from marijuana. Now, you could do field sobriety tests, and I guess your testimony indicated you would do both, right? And not either, but both, right? You would do a field sobriety. And so is that sort of your answer to my how are we going to, because we desperately need, and I just read an article where there are some good tests that I think warrant a bill being put in so that we, require those tests. But is that your answer, sort of like between finding it in your system and then someone who a trained law enforcement officer can see is impaired, that's how you would meet the standard that we would have for driving, charging the person under the influence?
You hit it on the head.
Okay.
You hit it on the head.
All right.
But, there are also certain things that could take place with the person who was high or drunk or whatever the case may be. They may be subdued or unconscious themselves.
Right.
So
Oh,
they
that's
won't be
very
able to
true. Yeah.
do a field sobriety test.
Because what I'm worried about really is not only that we don't have the proper safety protocols, which I don't know what Marylanders will do when they get hurt by this, but they can certainly look to us. But I'm also thinking about the fact that you're urgently making the case that we need this testing and codified, and I would codify it broadly in a sense of always updating it to the latest. What I'm worried about is we could be in a trial with a defendant, and without that component, I don't want to amend your bill, but it would be a great improvement, that we would be subjecting families and everyone to go through this, and a defendant would say, hey, you have no standard, I wasn't impaired, and Maryland would have an opportunity in this bill or a separate bill to put that some standard in place by which we could judge these defendants in that particular drug. I don't know if any other drugs are not really good at verifying your impairment by blood, but I don't think we have anything currently that helps us with marijuana.
Well, the beauty of your statement is that we're all on this committee together, and we can work on any amendments that could address any shortcomings.
Yeah, I'm not even suggesting that, but if you're not, I don't want to, I want you to be amenable, and I don't want to pressure you, but I think it might be a good idea to talk about it a little bit to see, because I did get some research on this, because I've been thinking about this. So would you just be open to it?
Yes, we can definitely sit down, and we can bring Ms. Green into the conversation.
I want the bill to work, don't, trust me, I do.
And bring Matt into the conversation as well.
Yes, all right, thank you, Senator.
Thank you so much. Senator West, then Senator Love, then Senator Muse.
Senator, I like the bill, but you emphasized the importance of immediate testing. The bill doesn't contain the word immediate. Would you have a problem if we added a little amendment to the end of the first page that says the person shall be required to submit as directed by a police officer to an immediate test?
I definitely would agree to that.
Great. Thank you.
Thank you, Mr. Chair. Thank you, Senator, for bringing this bill. Ms. Green, I'm so sorry for your loss, and thank you for coming in and talking to us today. I cannot imagine how hard that is. I do have one quick question. You said that the driver had a blood alcohol limit of 2 times over the limit. How did you know that? How do you know that if the driver wasn't tested?
Either you can come up or you can speak there, whatever makes sense.
I think there's a request.
You come up here then.
I found that information out well after the fact, after the case was over, well after that.
So somebody tested the driver at some point?
He was tested later at the hospital.
Got it.
Yes.
Okay, wonderful. Thank you so much.
I know that they pull someone over and they have what is it, 0.8, something like that, which is a limit for alcohol, is that right? 0.08, right. Is there such a limit for, let's say, other drugs, cannabis, particularly cannabis, because we've not really dealt with how you can tell what the limit is and how you can define the limit, and in no way to determine, at what level do you say impaired, other than what someone thinks? Is there such a standard?
So what Senator Delaney James was talking about earlier is there's no real standard as of yet, and they're still trying to figure it out. There are a couple of things out there, but we have to take a deeper dive into how do we truly track to see if somebody, because blood, if it's going to be in your blood. If you smoked marijuana or ate an edible 4 days ago, the THC is still within you. So there's no true guarantee or diagnosis of that.
So if an attorney came into court and defended one by saying, wait, you can't charge him or her with that, there's no standard. That would be an argument that is real. Is that correct?
We could run into that problem.
Only with that.
I just
Okay.
asked him all these questions, and what I suggested is we might do an amendment, because I have a couple articles on the latest testing that has come out for marijuana.
And how would yours?
I think if we broadly adopted some language on these testing so that as the technology improves, because blood will be not indicative but not definitive as we run the input. People are urgently coming up with ways to test this. So if you're working that amendment, and Senator Charles was open to that.
Thank you. Thank you, my friend, and I'd like to have that tie and that, and I'll vote for the bill, but I need, you can't say that out loud.
I saw Senator Folden wanted to say something. He was itching to hit the button. You may have something to add.
I'm itching to get through all of our bills today, but. Do you have something, Senator Folden?
Then, so this is a very difficult thing, and it's a very difficult topic, and I do, obviously, the loss is unimaginable to most, and the issue with the nanograms and not having a measurable standard is really an issue, and this isn't new. I mean, Colorado passed this, the first in the country, as I recall, in like 2014-ish, and they saw, and we're still trying to struggle 11, 12 years later with a measurable standard, and that's what it is. It's got to be a measurable standard. So it's a very complex matter. I mean, obviously, I'm 1,000% in support of the bill and keeping our roadways safe. So, but it's a challenge because it is about definitive, not just detected, but definitive and measurable. So, thank you. Isn't that so?
Isn't that so?
Well, thank you for bringing the bill, Senator. Ms. Green, thank you for coming today. I know it wasn't easy. We grieve with you and appreciate your being here today. That concludes the hearing for Senate Bill 110. Senator Muse, I promise we'll get to you, but next on the list in order is Senator Folden. If you're ready, Senator Folden, Senate Bill 129.
I want you to remember this. They say the first shall be last and last shall be, and you have to remember that my next bill, I am first. First shall be last, last shall be first. Something like that. And I jumped ahead of Folden there. I was like, this is my turn no matter what you do. No.
Okay, so we'll do Senate Bill 190.
Senate Bill 190. Thank you, Mr. Vice Chairman and members of this great committee. For the record, I'm C. Anthony Muse here to present Bill 190. I'd like to invite my sponsors, if they're still here, Jennifer Johnson and John Morris, if they are still here, to come up with me. Senate Bill 190 addresses how Maryland courts may interpret certain provisions of a will when questions arise regarding a descendant's intent. Specifically, the bill clarifies when a personal representative may petition an orphan's court to consider evidence beyond the four corners of the will and outlines the limited circumstances under which that evidence may be used. Under Senate Bill 90, a personal representative may seek court guidance, may seek court guidance when a will includes a legacy but does not clearly specify how that legacy is to be used. In those situations, the court may consider evidence of the descendant's actions during their lifetime to help determine intent, provided the evidence is satisfactory to the court. Importantly, the court retains discretion in making that determination. The bill also provides guidance in the case where a will contains specific administrative authority language, which is defined in the bill, granting broad administrative authority to the personal representative. When that language is present, SB 190 instructs the court to defer to the personal representative's judgment, absent compelling evidence or fraud. In addition, the bill establishes a limited time-bound mechanism for court-supervised oversight to ensure that legacies are administered in a manner consistent with the court's determination of the law. It also applies to estates probated on or after October 1st, 2021, and is intended to provide a consistent interpretive framework for courts and personal representatives in matters that may be pending. In closing, this bill provides statutory clarification for descendants' chosen personal representative, including those who also serve as caregivers, by clarifying when courts are to defer to that role while preserving oversight and accountability. Now, this legislation does not override clear or explicit language in a will. Rather, it creates a narrow court-supervised process to interpret intent only when a will is unclear. I ask for a favorable report, and I thank you for the committee's consideration. I'll open to who wants to speak first. Okay, would you come first and identify yourself as you come? Thank you.
Mr. Chairman, I'm John Morris. I'm a person who assisted Jennifer Johnson, who will be also testifying regarding how to solve the problem she encountered. Some time ago, the General Assembly affirmed as a matter of public policy the elimination of racial health disparities. That's where we start, and that's where the problem arises that this legislation is designed to solve. There's a conflict present regarding the intent of the testator. So where the testator believes that what I just stated, the elimination of health disparities, is public policy of the state, is the language of the will expressly intended to advance and promote that public policy without necessary clarification or restriction in the will itself? So can she depend on the public policy? Or is she providing a bequest irrespective of that? That's a question that the will itself doesn't answer if we're intent upon discerning the intent of the testator, the decedent. This legislation allows a personal representative identified by the decedent to resort to extrinsic evidence of the decedent's life story to determine what the intent was. In Ms. Johnson's case, the intent was compatible with the life of her grandmother, who was an active principal in the desegregation of the Naval Academy. To the extent this legislation would promote what the General Assembly has affirmed as public policy and enable the court to ascertain the intention of the testator, the decedent, I urge that this committee vote a favorable report.
Thank you, Mr. Morris. Ms. Johnson.
Good evening, everyone. My name is Jennifer Johnson, and I stand before you today knowing that no one in our state ever needs to walk through what I have been through. The terrible details of my situation and my grandmother's estate are in my written testimony for your review. I ask that you vote for Granny's Law, as it is good, simplified legislation that corrects historical wrongs in the probate system, one that has its roots of evolution in slavery. It also supports the work of your fellow Maryland General Assembly colleagues on the Public Health and Minority Health Disparities Committee, which has existed for 23 years. I am grateful for the people who are standing here, or rather sitting here with me today, to Senator Muse for leading the legislation in the Senate, for John Morris for writing the legislation and for being a cancer survivor, and for this young man, Amir, whose mother was a very close friend of mine, who tragically passed from colon cancer. Amir is doing great things, and his written testimony is available for you to read, and I encourage you to do so. I would also like to thank my Senate co-sponsors for supporting the legislation. Vote yes for Granny's Law and positively impact multiple generations throughout our state. Special thank you to all of those in the room who are here in support of the legislation and those that could not be here physically but were here with us in spirit. In total, we have 32 people that voted in favor and gave written testimony in support of this legislation, and only 2 opposed. Vote for Granny's Law and help restore dignity and honor where currently only tragedy exists. Vote yes for Granny's Law and honor my grandmother, a woman who was born and raised right here in Annapolis and who helped integrate the United States Naval Academy. Thank you.
Thank you so much. Question, Senator West.
So, Ms. Johnson, let me ask you a question or two, if I could. Could you come back up to the podium? This whole bill seems to be based on your personal situation, and your personal situation is entirely based on a particular will of your grandmother. Is it possible for us to get a copy of the will so we can take a look at the original will?
The will is actually already in the testimony from last session. It was not submitted by me, but it was submitted by the Register of Wills or the Maryland Judiciary, one of them. But it is in testimony already for
So I could find it by going to the bill that was
1029
introduced last year, I guess, in the House?
in the Senate.
Oh, in the Senate?
Yes.
In the Senate, and take a look at the, okay, I will. Because, you know, the rule in Maryland is that if there's no ambiguity in the will, there's no interpretation needed. The court gives effect to the actual language of the will unless the will is ambiguous. So I'm a 40-year, almost 50-year lawyer. I'd like to take a look at the will and see whether I find any ambiguity in there.
Sure. I would just like to give further clarification of something. The language in my grandmother's will is very common in most people's wills. If you look at the testimony from last session in the House, you will see where the Register of Wills said basically on record, they treat that language as boilerplate language to be ignored and dismissed. This is a very common problem where the courts are overriding people's wills such that lawyers and judges can make large profits. In the case of my grandmother's will, there was very specific language in that will, and I was yelled at, screamed at to ignore that, and it does not mean what it meant. It definitely does. The motto for this legislation is I meant what I signed. my grandmother meant what she put in that will. The judge yelled and screamed that I was to ignore that I was also to ignore Maryland public policy against health disparities. They also ignored 8 expert witnesses testifying to the disproportionate need that African Americans face in health disparities. And they ignored my grandmother's will and did everything that was not something my grandmother would have wanted.
All right, well, since this bill is so much about your particular will that you were concerned about, can I ask you 5 questions, each of which I think can be answered with a single yes or no answer? First of all, were you removed as the personal representative of your grandmother's estate?
Yes.
Secondly, was your removal affirmed in circuit court?
Yes.
Thirdly, were you held in contempt for failing to obey an order of the Orphans Court?
No.
Didn't the Orphans Court tell you to release some documents, and you refused to do that?
I have no charges against me.
Okay.
And was never charged.
Fourth question, did you slap your attorney in court?
No, I didn't.
Okay. Fifth question, did you transfer $1.7 million from your mother's estate to yourself without prior court approval?
No. And let me also explain several things to you.
Well, let's explain that.
Hold on. Let's take a pause here. So the legislation before us is a policy. It's not specific to the case in front of us. I'm happy to give you, Senator, the flexibility that you want, but what's before us is not specific to the case. It's just the idea that brought the legislation. And so I'm not sure how fruitful this line of questioning might be, and perhaps to the extent that you are curious about the specific case, the two of you might be able to talk offline if that.
We've actually talked numerous times.
I'll take the sense of the chair's questions, and I'll withdraw my question. Thank you very much.
Thank you, Chair.
Senator James.
Oh, thank you, and I apologize because I know you gave great testimony and you already spoke, so I may have missed this, not trying to tread over what Senator West asked for. And you can provide this afterwards, but even though we need to, we're trying to come up with a policy for the state of Maryland, as Senator West said, it's sort of driven by your circumstances. So the more we know about your circumstances, not that we're going to highlight that, but we want to understand what drove it, because sometimes, and I love your senator, sometimes you can come up with a solution, but when we all understand the driving force, we tweak it. So what would be really helpful, as Senator West, they said, get the copy of the will. But if either of you can now very succinctly just tell me if it's this simple, the phrase or just a real summary of the provision you just mentioned that you said everyone said to ignore and dismiss it. Can you just explain that to me in a couple of sentences, what that provision was?
In addition to the powers conferred upon personal representatives by the state of Maryland, my duly appointed, my personal representative or any duly appointed successor trustee does not sit under the adjudication, order, or direction of the courts and can do multiple things, one of which is anything and everything as fully as if I were living.
So that was in the will or a power?
That's in the will.
So wow, you know it by heart. So just say it one more time, because then I can listen to it later and write it down. Go ahead.
And it's also, again, a written record.
Right.
In addition to the powers conferred upon personal representatives or trustee by law.
Right.
My personal representative or any duly appointed successor trustee can do any and all things. Does not sit under the adjudication, order, or direction of the courts. And one of those things that is listed as the things that they can do any and all things just as fully as if I were alive. I will give you an example of something. First off, my grandmother would never have wanted strangers to have their hands on her money. That's first and foremost. But my grandmother had a CPA that she used for 31 years.
Yes.
She had already started the estate taxes and everything. Her fee was about $400. The people who took my grandmother's money used somebody we had no knowledge of, $4,000 plus.
Who drafted the will? I apologize. If you explained all this.
It's in the, his name escapes me right now, but yes, it was a lawyer.
So it was a lawyer in Maryland, licensed, okay. And did the lawyer or anybody explain to you, because I am not familiar with this phrase, and I do some estate trust, probably Senator West does more, but does not sit under the adjudication of the court. That is throwing me a little bit. Do you recall any discussion about that? Because I'm thinking that might have been what the court was troubled with, but
The court was troubled with it,
Right.
but I am equally troubled that they ignored my grandmother's will.
Oh, no, please.
They ignored Maryland state policy, and that they are doing things that are not beneficial to any Marylander.
Look, when I'm asking you questions, I'm not against you. I'm educating myself. Senator Mr.
Right.
Tugg, we're educating ourselves. I'm just trying to narrow in, and everything you just read to me, the phrase that was unfamiliar to me in some estates and trusts was, does not sit under the adjudication.
Yes.
Did you have a lawyer or anybody, that knows this stuff say to you, because you said this was boilerplate. Is that paragraph that you can recite by memory? Pretty impressive. The boilerplate that you were talking about earlier?
That's what they like to consider boilerplate,
Okay.
but it is actually what most people want in their wills. They do not want lawyers taking large fees or foreign people handling their money. When they put someone in charge of their estate and their demise, they want that person to handle their business affairs.
Right, it's true. Maryland law does not compel you to hire a lawyer. You can be a personal representative at your own peril or not. Right? So, and some do and some don't. And the estate judges, the orphans court, are trying to be pretty helpful because they don't even have to be lawyers in some counties. Sounds like you were not in the greatest place. So I just wanted to narrow that down, that I'd like to see the will. And again, I'm sorry you answered it. A lawyer in Maryland, and maybe you could tell me later the name of the law firm or lawyer who drafted that provision, and anything you have about the court. Maybe a court reporter. I don't know. Anytime you could find that it's written, I believe you, but it's written where the court was saying this is boilerplate, and also it's going to be ignored.
It's actually
there might be a
not in
transcript.
writing, but it's on the visual video from the House testimony last session.
Well, I was saying that if you were in a court proceeding, if the court said that, then a court reporter would have been, whether you realize it or not, a court reporter, or nowadays, I guess it's all, they don't even use the human, is recording everything that's said in open court. So that, some of this might have been said in open court. Oh, you know what you could do, Senator? You could probably give us the case name and ID, but if you could help us in any way, we could go look at the docket, and if you have any recollection, tell Senator Muse when some of those statements you thought were made, what hearing it was, and I'd like to go and see
I
that.
have the audio transcript.
Oh, would you?
It's public record. You can
Okay, would you be able to get us that?
Yes, I'll get that to Senator Muse. I just would like
well,
to.
thank you. Thank you,
You're
Mr.
welcome.
Chair.
Thank you so much. I appreciate it. Any further questions?
I would just like to close with this.
No, so we had our time with the testimony. Senator West, do you have one last question?
It'll be quick, thank you. I'm looking at the will from last year's testimony, and it looks like your grandmother gave 5% of her estate to 4 organizations. 1, the American Heart Association, in parens, for research. 1, the American Cancer Society, in parens, for research. 1, the Alzheimer's Association, in parens, for research. And finally, to the Alliance for the Mentally Ill of Maryland, Inc. What do you claim is ambiguous about those directions?
Okay. Let's just do this one more time. We have an individual case that is inspiring the bill, but this is not the place to relitigate the underlying case. And so if there's a question that will help inform your position on the bill, please ask it, even if it is specific to the case.
The argument is, this whole thrust of this bill is to allow people who didn't make the will to come in and reinterpret the will based on alleged ambiguities in the will. So I'm looking at this particular will. I don't see an ambiguity. These directions seem awfully clear. So I'm wondering what ambiguity is complained about, which has precipitated this bill.
Okay, let's go one more round on this, and then I think it's time to move on.
Sure. They refuse to use the money to benefit African Americans. Maryland public policy is to work towards eradicating. Can I finish, please?
Sure.
Is to work towards eradicating health disparities. Who has health disparities? African Americans have the largest number of health disparities. My Black grandmother, my African American grandmother, who helped integrate the United States Naval Academy, was not giving money to those charities to further harm African Americans who are in dire need of help. She was not.
Okay, I hear you.
Right,
Thank you very much.
Thank you.
Get together with you and pull some things.
Sounds good. Thank you all for being here. Amir, you're the man. We have some stuff in the back. If you're interested, candy, maybe. Oh, you did great. Thank you for coming.
Thank you.
That concludes the hearing on Senate Bill 190. We'll now move to Senate Bill 129, Senator Folden.
Better hop up there before somebody else jumps.
Okay.
All right. Mr. Chairman, esteemed colleagues of Judicial Proceedings, for the record, William Folden, State Senator for Frederick County, District 4. Before you today is Senate Bill 129. This bill is very similar to last year's piece of legislation. In simple, SB 129 expands the meaning of the term a victim of domestic violence and allows for a warrantless arrest where a police officer has probable cause to believe that the perpetrator battered another person with whom the perpetrator has had a sexual relationship within the past year, regardless of residence, whether they reside with them or not. I also, part of this that was missed, and I do want to make the committee aware, there is a amendment forthcoming that would change the authorization to make a warrantless arrest from its current posture, which applies to battery between any cohabitant, and I use that word specifically, to instead allow for warrantless arrest only where there is a familial or intimate relationship between the victim and the perpetrator. And that is the roommate rule. That would be the opportunity to where you have two roommates, they're watching a ball game, they're both big supporters of each team, they go and have a little dust up, there's a mutual assault, police respond. Right now, they have to do the whole course as though that's a domestic violence incident, only because they live together. There's no intimate relationship, there's no familial relationship, and they have to fill out all the paperwork. So it's really an inaccurate reporting of what we're intended to do for the domestic violence measures. So that was one that was not included in this that I will be adding in. And with that, I would kindly ask for your support and favorable report on SB 129.
Good afternoon, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in support of Senate Bill 129 with sponsor amendments, including one that was not mentioned by the sponsor, but I'm hoping he still supports. Senator Folden, thank you for introducing this bill, and committee, I see a lot of you during session, so it is always a pleasure to appear before the committee. We do strongly support this bill. The Maryland Network Against Domestic Violence also authorized me to say that they also support the bill. The sponsor amendment that we believe will be introduced will, instead of saying another person with whom the person's had a sexual relationship with in the past year, to instead just reference the protective order statute. So if someone's eligible for a protective order statute, that they would also fall under this warrantless arrest category. That provides some consistency in the law. It's clearer. And I do want to emphasize two things. One, that this really is a fairly limited number of cases that where there's a warrantless arrest. There's evidence of physical injury, and unless the person is arrested immediately, the person may not be apprehended, might cause more damage either to a person or property, or might spoliate evidence. And on top of all that, the report has to be made to the police within 48 hours of the alleged incident. So this is it's a narrow category, but we know in these family cases, family abuse cases, domestic violence cases, that often they happen in private, the police come later. And I would say, Senator Sidner, I know we have talked a lot about commissioners, and although we may not completely agree on the solution, I agree with you completely that there is a problem with the commissioner system, and I think that this is something that goes down the path of correcting the whole system. Because right now, what What survivors are being told is go to the commissioner. This would instead give police the opportunity to intervene. For those reasons, we ask for a favorable report on Senate Bill 129 with sponsor amendments.
Thank you so much. We'll now go to virtual. Ms. Feinstein, please. Go ahead.
Good evening. My name is Debbie Feinstein. I'm the Chief of the Special Victims Division for the Montgomery County State's Attorney's Office, as well as the co-chair of the Legislative Subcommittee for Special Victims Issues and Special Victims Prosecutions for the Maryland State's Attorneys Association. And I'm here today to testify on behalf of the Maryland State's Attorneys Association in support of Senate Bill 129. I want to pick up where Ms. Jordan left off. With the current commissioner system, individuals who do not fall into the current delineated categories are essentially rerouted to go to the commissioner and have to take out their own charges. So this is really an access to justice issue. We have individuals that have been in the same kind of intimate relationship with the abuser who are not getting the same type of access to justice as someone who potentially lives with someone. We're really looking at a narrow category of cases. As Ms. Jordan said, we're not thinking that this is going to so greatly increase the burden on our police department. In fact, what ends up happening in reality is we get citizen-generated complaints through the commissioners, and then we have to ask officers to get involved after we have a statement from a victim when they've gone to the commissioner, and potentially to do additional investigation that would have been better done at the time. For all of those reasons, we urge support of Senate Bill 129. This really does create access to justice for more victims of domestic violence. It also creates a system that will diminish lethality because individuals are arrested more quickly. The victims are not required to go to the commissioner to get these types of charges, and we'll see a better outcome in the prosecution of those cases. Thank you for your time this evening.
Thank you, Ms. Feinstein. Questions? Senator Henson.
Sponsor. Talk me through how this works practically. So if you go somewhere and you see the injury, so you have that threshold that's met, you talk to one person, and I guess you have to start inquiring about their sexual history. You have to ask those uncomfortable questions. If you see two people, doesn't matter what you might think about their relationship to the other. Now it would impose that responsibility for our officers. You might think they're roommates, you might think whatever, but now you got to ask the two of them, what's your sexual relationship with each other?
That would be the part that's solved in your amendment. Yeah, so the amendment would be that, and this is the amendment, I apologize, I didn't introduce it, it is in the folder as an amendment, that another person who is eligible for relief for a protective order or a temporary protective order against a person under sections 4-505, 4-505.1 or 4-506 of the family law article. So that's, it would narrow it down that way. You're still going to continue practically with that discussion and inquiring as to what the actual relationship is. This stems actually because we had law enforcement who were actually making domestic violence type arrests, on-site arrests, for a second-degree assault that did not occur in their presence between roommates, which was not the intent of the DV laws. And yet we would have those that were actually being stalked or actually being, abused, but they no longer reside together. They're not in a relationship any longer, but they're still dealing with the threats and all the other abuse that is subsequent to the relationship. So those are the ones that is actually, it's still a continuation, if you will, of the domestic violence because it's precipitated from the initial relationship. So that's why I felt it was important to make sure that we are covering those affected, those victims, beyond the termination of the relationship where they just live together. It was just kind of a gap. It closes the gap where we had people that were not able, or our law enforcement weren't able to do a warrantless on-site arrest for basically what would be deemed a second-degree assault between two people that had an intimate relationship in the past, and the assault was a result of or continuation of the abuse that they were enduring.
Is your intention to open it up to everyone who's eligible for protective order? So everyone that's related by blood, marriage, or adoption, people yes. who have a vulnerable adult, people who have a child in common, people who have a sexual relationship. So to your point, you would open the door to everyone under that umbrella, but then we still get back to the uncomfortable conversation that officers, you got to kind of ask everybody those questions, but sure. then you have to ask everyone, no matter what you might think about two people's relationship to each other, are you all in a sexual relationship? And then you have to drill down even further. Have you had sex within the last year? And then you got to get, to those details. And I guess, I don't know if we have definitions in here of what sex is, and having those conversations after someone has been harmed and you see the obvious signs of harm. But it sounds like it would require a great deal of training with our officers to be able to have those conversations and to ask them in a way. And then what happens if you have two different stories? If one person says, yes, we have, and one person says, no, we haven't.
Yeah, it's not an uncommon situation, unfortunately. And officers spend a lot of time because, like I said earlier, two most violent and dangerous things to an officer, traffic stops, domestic situations, because it involves matters of the heart. So you're really going to have people that are irrational, they're worked up, they see things falling apart in a manner. So it is incumbent upon them to be good investigators, to separate, to investigate, to ask those difficult questions, to make sure that they're documenting all those things, because they're not just going to do it, at willy-nilly. There's going to also be like other, years ago when I put in about the strangulation protocols for law enforcement. Law enforcement was missing indicators that were there, whether it was the petechia in the eyes or in the mouth, and these were some things where you would ask certain people about, hey, were you strangled? And they're like, no, I wasn't strangled. Okay, but he choked you. Yeah, he choked me. So it's just about an education on both things, where we have to educate the citizens we're dealing with at the same time about what some of the language means, what the situation is, and then do the good, solid investigation.
How does that help with de-escalation? If now you have to come there, somebody's been obviously hurt, and now you got to ask the two of them, hey, are you two in a sexual relationship?
Well,
not only that, have you had sex in the last year?
If they're in an intimate relationship, that's usually early on. It's really known pretty quickly.
Well, we can't assume now. You would have to do that sort of screening for two people, even if you maybe wouldn't have assumed that.
No, the exclusion would be is if they're just like roommates, or if there's something like that. That would be the exclusion part of it.
Well, you would have to know, though. Now it's putting that duty, because we can't discriminate. If two people are in that relationship and that officer can make that arrest, we would want them to do that.
Correct. And so what it does also is so when someone is in one of these under the aforementioned areas of the law, under the family law article, it also triggers an additional responsibilities by the officers, because there's domestic violence forms they got to fill out, and there's other protocols. They have to go and actually do an interview. They have to offer the victim to write down where they were injured, mark where it was injured, write a brief synopsis of what happened. There's a lot of time on these incidents where officers are doing certain things to continue to build, to your point, a solid case as to what transpired, okay? Sure. The ones we're trying to minimize is the ones where we don't want to be doing all that extra work once it's deemed early on, like it was two roommates, as far as this part of it, I should say, where it was two roommates that were just having a dust up because they didn't like the outcome of a football game, and they were on each side of the fence, and they had a little spat in the room. That's not the intent, but as it's currently written, they would fall under the DV guidelines.
I hear what you're saying, but if the dividing mark is a sexual relationship, we would just have to make sure the officers were trained to not make any assumptions about those two roommates and to ask those questions so that we could make sure we were checking those boxes appropriately.
Agreed, and
I
they have
appreciate
it.
it.
Thank you.
Thank you, Mr. Chair.
All right, seeing no further questions.
Thanks, Debbie, for staying late.
Thank you. Take care.
See you, Debbie. All right. All right, so that'll conclude the testimony for the proponents of the bill. We'll now switch to Ms. Stofa, who is signed up to testify in the opposition. Welcome. Good to see you.
Welcome. Good to see you. Thank you for having me. My name is Tamara Stofa, and I'm here today to ask for an unfavorable report of Senate Bill 129. I am with the Office of the Public Defender. I work here on the Eastern Shore. I'm the District Public Defender. And my concerns are what I heard from some previous questioning is that this bill is overly broad and gives too much discretion to the police officers. Having an arrest warrant is fundamental to our Constitution, It avoids the concerns with untruthfulness. Sometimes that can occur in these situations, and or the one-sided stories that we might see. It certainly does not prevent the police from investigating and ultimately arresting someone later on. And despite the fact that I heard that this covers a narrow scenario, I think this covers many scenarios that I have clients that would be affected by this change in the law and allowing them to be arrested without a warrant, without judicial oversight. Additionally, I will remind this court that it does also change the definition in this bill in the family law article of who is concerned with domestic violence. And I will remind this committee that the policy of the General Assembly under Family Law 4-514 is to recognize that the victims of domestic violence are forced to leave their homes to ensure life, safety, and welfare. And victims of domestic violence and their children are also economically dependent upon the abuser and have no place to live outside of the household. And in the past, domestic violence have been ignored and lack counseling and services. So by changing the definition or including this in the definition, we add additional funding resources for other classes of people that have their own homes, that are not dependent upon the person they're alleged to being the abuser in this case. But I would ask for an unfavorable report.
All right, excellent. Thank you very much, Ms. Stopa. Questions from the committee? All right, seeing none, thank you very much.
Thank you.
Excellent. With that, that'll be the end of the hearing for Senate Bill 129. We'll now move on to Senate Bill 12. Senator West.
No, but I've been slapped on any number of occasions. Thank you, Mr. Chair. It is a pleasure to be with you for the first time this year, not the last, to present Senate Bill 1. Senate Bill 12, 12. The premise of this bill is very simple, that it gets really, really hot these days in Maryland in the summertime, and that living without air conditioning in such conditions can actually be dangerous. This bill presumes that a rented residence without air conditioning could be just as unacceptable as a rental without heat or water or indoor plumbing. Given the extreme summer heat in Maryland, our citizens who live in rentals should be provided with decent air conditioning. So what does this bill do? It would require residential rental units in newly built large multifamily apartment buildings to have air conditioning sufficient to cool the apartments down to at least 80 degrees. This would also extend to existing apartment buildings that undergo the complete replacement or substantial upgrading of their electrical systems or their heating systems. In other words, if a landlord's going to spend a lot of money upgrading an existing building, the installation of air conditioning should be a part of the project. Last year, an earlier version of this bill was introduced by Delegate Lehman in the House and passed that body overwhelmingly, but it was opposed by various organizations representing landlords. Their opposition was not based on the basic thrust of the bill, but was based upon the fact that the bill required that Maryland adopt standards promulgated by a particular national organization. This year, that requirement has been deleted from the bill. Instead, the bill merely invokes the 80-degree requirement, something that's easily measurable with a standard thermometer. Also last year, the city of Baltimore was concerned that the bill would apply to a number of very old city-owned public housing structures with electrical systems not capable of accommodating building-wide air conditioning. So language in this year's bill has been added exempting buildings falling into that category. My information is that there are 9 of those buildings, and collectively they contain 4,500 rental units. We're talking about very, very old buildings dating from the 1950s and 1960s. which were built back in those days with no air conditioning. So I believe that we have successfully obviated the objections that were encountered last year. Now, I understand that there are two witnesses, one who's testifying in favor, Mr. Shaw. He wonders whether or not the bill should contain a provision saying a county can introduce legislation at the county level which would be more stringent than this. In other words, would reduce the temperature to 78 degrees or 76 degrees rather than 80 degrees. The default rule in Maryland is if we don't say anything, that counties can do that. So I don't think there's any need to add an amendment to this bill to actually state that, because that is the default rule when Maryland legislation is passed. Also, Mr. Hill will testify and oppose to the bill. He wants Baltimore City to have to rectify the problem in those 9 old public housing structures now at the cost of many $1 million. As I said, the reason the bill this year was changed from last year in order to get rid of the city's objection to the bill. So Mr. Hill, I think, wants basically to go back to last year's bill, in which case the city of Baltimore would come in vehemently opposed to the bill because they can't afford to fix those 9 buildings all at once. This may be a case of Mr. Hill wanting the perfect and letting that get in the way of the exceptionally good. I think this bill is exceptionally good. It is not perfect. There's room for improvement in future years to get Baltimore City to convert those 9 public housing structures to air-conditioned structures. But we can't do that this year. So I think it's better to establish this as a base, applying to all the all the rental structures across the state from now on, and then in future years to try to make improvements. I should also point out that this bill has no fiscal note. So I appreciate the committee's consideration of the bill. I think Mr. Huang and Zafar Shaw, Mr. Huang I think is remote, Mr. Shaw is here, are going to be testifying on the bill, both in favor. Mr. Huang is totally in favor, Mr. Shaw in favor with amendments. And I'll be happy to take questions.
Excellent. So we'll do the, finish up with the favorable. So Tim, welcome. You're up next, and then we'll go to Mr. Shaw.
Thank you. Good afternoon, Chairman Smith and Vice Chair Walstracher, the members of the Judicial Proceedings Committee. My name is Tim Huang, and I'm representing the Montgomery County Renters Alliance in support of SB 12. The Renters Alliance thanks Senator Chris West, as well as Delegate Mayor Lehman, for laying the groundwork for this important legislation that will protect tenants from ever-rising heat and climate change. SB 12, as you've heard, requires new construction of buildings with at least 40 units to provide tenants with air conditioning. As record high temperatures become increasingly more common, we need to protect our tenants. I know during some of the coldest time of the year, it's hard to imagine that, but think of to when summer is going on and how intensely hot it is. And then many of the tenants who are elderly, disabled, or young children would have hard time, with studying, with cooking, with working, and potentially having issues, heat stroke, when the temperature is over 80 degrees inside. Montgomery County passed similar legislation in 2020 with the desired effect of protecting renters. Heating is already mandated in the winter months, and so I think it's time for us to catch up to make sure that air conditioning is standard as well. And in addition, unlike if it's too cold, if your heat is out and you can just plug in a space heater, it's much harder for a tenant to try to cool their unit on their own. And it's much more effective to have the building have a central AC system. So we can't affect the effects of climate change that's causing more extreme temperatures. And for that, the Renters Alliance urges a favorable report on the bipartisan supported legislation. Thank you.
Hey, good evening, Mr. Chair, Mr. Vice Chair, members of the committee. For the record, Zafar Shaw, Maryland Legal Aid. As Senator West, and thank you, Senator West, for sponsoring this bill. As you noted, we have a couple concerns at Maryland Legal Aid, although we vehemently support the intended impact of bringing cool comfort, thermal comfort to our clients across the state who are low-income renters. the HABC is asking essentially to not be impacted by this bill, regardless of whether they completely renovate and reconstruct their properties. So an example of this is Poe Homes in Baltimore City, which is undergoing a complete rehab and rebuild under HUD's Choice Neighborhood program. Under the language of this bill, in spite of the fact that there's new wiring and new systems, they would not have to meet the 80-degree threshold established in this bill. So the exception in the bill doesn't make a lot of sense. We just want it to make sense. If you have a bill focused on future-proofing Maryland rental apartments so that in the future they are constructed better and can reach that 80 Fahrenheit threshold, it really doesn't make sense to Maryland Legal Aid that the Housing Authority and 65% of their available units today don't have to, in the future, meet that standard. I'll say, too, that I did not address this point in my written testimony, but it did occur to me as I thought more about it that today's properties that do have air conditioning still need a standard to meet. And today, like when Legal Aid sued a landlord in Baltimore City under the Tenant Safety Act for failing to produce air conditioning, although it has an HVAC system, the judge found that we couldn't hold the landlord accountable for this subsidized housing project because the city did not have an 80-degree threshold. We hope that the committee adopts that threshold, and we support this bill with a favorable amendment.
Thank you very much, Mr. Shaw. All right, with that, we'll open it up for committee for questions. Senator McKay.
Senator? Providing air conditioning, so can the landlords provide a window unit?
Yes.
They can do that.
So long as the room gets down to 80 degrees. That's the standard.
Okay. Second of all, I see where the bill does talk about 4 or more individual dwelling units.
Right.
It's talking
It's
about
the
that
typical definition of multifamily.
Yeah, it's not a good definition. It really isn't. It's just, there are, anyhow. So my question has to do with homes that are, I see in the bill it talks about if it's in a historical area, they're exempt from this. But what happens if it's an older home that is not in a historical area? Not every older home is in a historical area. And a good example would be a 10,000 square foot building that has approximately 5 units in it. And the heating plant happens to be 2 gas-filled boilers. Under this law, if the said owner of 10,000 square foot building would have to replace the boilers because of Maryland's mandate of being against natural gas and those type of things, we would end up having to rewire the whole entire building for the said air conditioning. I don't know why the historical designation is there and it's not based upon a building built before or not.
The historical designation is property listed in the National Register of Historic Places. So it's you can turn to the National Register and you can find whether a property is at a particular address is in the National Register. Anything that's not in the National Register would not be included. So we're not trying to establish a different standard for whether a building qualifies as historic.
But it does.
It does?
It does, because it says those who are exempt are those who are in the National Registry. So if you're not in the National Registry,
then you're not exempt.
Correct. Correct. Why is that a difference?
Again, just the standard of 4 units as separating multifamily housing that's not covered or multifamily housing that is covered is the standard definition I've seen any number of times in Maryland statutes. We might want to consider changing that to a higher number. It sounds like you're advocating for at least 5 or 6.
I tend to believe that there are units in the state of Maryland that this will be cost prohibitive for them to continue just a standard of replacing the boiler systems in this case, much less an HVAC.
Well, of course,
A building.
this bill doesn't cover boiler systems.
No, but it does say that if you replace the heating system or the air conditioning system, you have to bring it up to standards. It says the replacement of substantial upgrades to electrical systems or heating systems.
Or heating systems, right. I guess that's right. So if you're, I suppose that's correct. If you're going to replace the heating system in the house, which is a substantial expense, you ought, at the same time, you ought to put air conditioning in the house. Now, this assumes the house has more than 4 dwelling units in it.
Correct.
Right.
Yeah, I have a particular street in the city of Cumberland that has many of these homes that have exactly what I'm talking about.
Well, why don't we sit down after the hearing and talk about ways we can accommodate your concerns.
Okay, thank you.
We could increase it from 4 to 5, from 4 to 6. A residential house only has room for a certain number of dwelling units in it.
Right, I understand that. So, thank you.
Sure.
Look forward to it.
Yep.
Thank you. And just speaking to what Mr. Zafar Shah was kind of noting with Baltimore City trying to essentially exempt themselves out of it. I understand affordability, but if you're...
That's the reason.
Right, so, but that can be planned for.
Yes.
Right, so I mean, there could be something in the legislation that gives them time to plan so that by a date certain, these units could be done. I mean, because I was kind of thinking about when they're in road improvements under the ADA, if certain things happen, government doesn't necessarily have to put in the ramps until the road has been maybe repaved, or there's something that triggers, now you have to comply with the law. So I just put that out there just to consider.
I think Mr. Shaw's idea has a certain appeal, that if these one or more of these 9 public housing projects in Baltimore City, each of which contains many, many rental units, if they're going to do a lot of upgrading to that particular one, why shouldn't they put the air conditioning in while they're doing that?
I agree.
So we can talk about that as well.
Thank you.
Further questions from the committee? All right, seeing none, that'll conclude the hearing for Senate Bill 12. We'll now move on to Senate Bill 140, Senator West.
Okay. Thank you, Mr. Chair. It's, again, a pleasure to stand before you and present this bill, Senate Bill 140. This is a reintroduction of Senate Bill 170 from last year. This was Delegate Aaron Kaufman's baby, and I was happy to take the cross-file last year, and once again, I've got the cross-file this year. This bill would create a new crime involving the exploitation of someone's government benefits. The crime would have 3 elements. First, a person would need to be found guilty of using deception, coercion, exploitation, or isolation of any means. These terms are all defined in the bill. Second, through such means, the person charged with the crime would have to be found guilty of knowingly recruiting, harboring, transporting, or obtaining an individual as a victim. And thirdly, that conduct would need to be found to have been perpetrated for the purpose of appropriating the government benefits of the victim for personal benefit of the defendant or to benefit somebody else, not the victim. In other words, the crime would be similar to human trafficking, but would instead could be referred to as benefits trafficking or benefits exploitation. In the context of this bill, benefits exploitation could best be described as the systematic recruitment, harboring, and financial exploitation of elderly and disabled adults and adults suffering from dementia who receive government benefits such as Social Security, veterans benefits, Medicaid, Medicare, pension benefits, disability benefits, or other government benefits. Such exploitation occurs with alarming frequency, I am told. The exploiters tend to pose as sincere individuals, offering to provide care for at-risk adults in an in-home setting. And then once recruited, the at-risk adults sign over their government benefits to their caregiver. From that point on, the victims are held against their will, while their caregiver receives their benefits and uses them for the benefit of the caregiver, not for the benefit of the victim. In extreme cases, the victims are moved from location to location and denied basic needs such as food, clothing, and adequate shelter. Victims of benefits exploitation are often forgotten, at-risk adults who have fallen through the cracks of various mental health systems, are unhoused, and no longer have a social support system in place. So benefits exploitation is deceptive and predatory behavior, causing extreme detrimental harm to individuals and families. Among the organizations supporting this bill are the Alzheimer's Association, the Associated, the Maryland chapter of the National Association of Social Workers, the Maryland Department of Aging, the Maryland Department of Human Services, and Mayor Brandon Scott. There's no fiscal note on this bill. Sarah Mickey is here to testify in favor of it, and I appreciate the committee's consideration. And once Sarah is finished, I'll be happy to answer any questions. Thank you.
Good evening, Chair Smith, Vice Chair Wallstreicher, and members of the committee. I'm Sarah Mirsky-Mickey. I'm the Deputy Director of the Baltimore Jewish Council, which represents the Associated Jewish Community Federation of Baltimore, all its agencies, including HANA, the Jewish Response to Abuse, Trauma, and Neglect, including elder abuse, here in support of SB 140. As Senator West explained, this bill creates the criminal offense of benefits exploitation. I'm sure most of you saw over the fall and early winter the expose around elder abuse in our state, and specifically around what was happening in unlicensed facilities, around their benefits being wrapped up and adults being trapped in those facilities, being fed rice and beans, being told that they were not allowed to leave their facility or that they would be punished in some way. This is also true and happening in licensed facilities as well. In terms of HANA, we represent a lot of clients for in-home care. So we had a client through HANA who was an older gentleman being taken care of by their adult child. They were forced in their basement all month and abused and barely fed. And once a month, they were taken out when their benefits hit to give those benefits to their older adult child. So we have a clear and current and unfortunately very regularly occurring problem. And for these reasons, we ask for a favorable report on SB 40. Thank you. 140.
Excellent. Thank you very much, Ms. Mickey. Questions from the committee? Senator Henson.
Penalty for this, what struck me is you mentioned in your testimony that in an extreme case, so that's an acknowledgement that there are varying degrees of awfulness here. Right. But the penalty for it is a guilty of a felony and on conviction is subject to imprisonment not to exceed 25 years and a fine of $15,000. So it is a felony conviction. Is there any willingness, understanding, appetite of the sliding degrees of culpability or sliding degrees of awfulness that could happen with what you've described in the bill?
This is the worst that could happen. Typically, the cases are plea bargained between the state's attorney and the attorney representing the defendant. And in an appropriate case, it would be degraded to a misdemeanor, not a felony. And the prison sentence, if there were to be one, would be much lower than 25 years. And the fine would be lower than $15,000. But in an egregious case, I couldn't imagine any crime that I would less like to see branded as a felony than this one. And someone in an egregious case ought to receive the full penalty provided by the law, 25 years in jail. If you subject people who are suffering from dementia to these kinds of conditions and confine them to a basement, we ought to be able to throw the book at them. But in an appropriate case, that won't happen.
I agree, but the bill also provides for someone who knowingly benefits from that. What if you have someone who knowingly benefits from the finances that's wrongfully obtained? That person similarly is convicted of a felony and could be incarcerated for up to 25 years as well.
Again, could be.
Understanding.
But that person will have his or her own lawyer and will negotiate with the state's attorney. And the state's attorneys that I've experienced are quite sensitive about gradations of culpability. and they'll settle for a lower offense if the person pleads guilty. And it won't, in a small case, it won't end up being a felony.
Just curious, what's a lesser included? If we're looking at that gradation that you're talking about, what's a lesser included offense in that scenario?
That's a
where
good
you're
question.
a person that's also, let's say you're the wife of someone who's doing this awful crime, and you are benefiting financially because your spouse is doing that, and you know your spouse is doing it, but it's how they're paying the bills. And so you're similarly arrested, and the criminal penalty here is a felony. And your assumption is that a state's attorney would enter into a plea deal with that wife whose partner was doing that.
Right.
And we're looking at lesser included offenses. What are those, just out of curiosity?
I don't think you have to have a lesser included offense. You could plead guilty to a misdemeanor. And
How so? This says they're guilty of a felony.
Yeah. They could plead it down to a misdemeanor.
I don't believe so. This says the violation is guilty of a felony. So we would have to have some sort of amendment that said there was the possibility for misdemeanor. Now, if there were a lesser included misdemeanor of conversion, or I don't know, that's why I'm throwing that out there to ask and to make a record. If there's something that you think is a step along the way, that's a misdemeanor that might be included as well. That's a possibility, but I'm not a criminal practitioner, so I was just curious.
But it's a good question. I will call a criminal practitioner. I'll call a state's attorney, and
Okay.
I'll get the answer to your question.
I
and
appreciate
get back
that,
to you
Senator.
promptly. Thank you.
Thank you, Mr. Chair.
So page 4, lines 8 through 10, you speak to a sentence being imposed being separate from and consecutive to or concurrent with. I'm curious, is there a preference that you may have regarding it being consecutive or concurrent?
No, it would depend on the circumstances of the case. And it would be up to the state's attorney and the judge whether or not they were to invoke this provision.
Right, but so, I guess kind of falling in line with what Senator Henson, you got 25 years. If it's consecutive, it's going to be whatever else plus 25 years.
Consecutive, right, or concurrent would be...
It could be ran along with any other crime that may have been...
Assuming that the defendant were to get the full 25 years.
Right.
Right.
So you're fine with that?
Excuse me?
You're fine with that consecutive?
Yeah.
Okay.
It's not unusual in criminal statutes to find this language.
Okay, thank you.
All right, additional questions from the committee? All right, seeing none, that'll end the hearing for Senate Bill 140. We'll now move on to the final bill of the day, Senate Bill 177, and Senator West.
Thank you, Mr. Chair. Final bill of the day, and this one, I don't think we have anybody in opposition, do we? We have 2 supporting witnesses, so this should go pretty quickly. This is Senate Bill 177. It's a pleasure to be here and present it to you. It has become a sad reality of our time that there's an uptick in anti-religious extremism, regardless of faith. In particular, the wave of anti-Semitism, which we've experienced since Hamas attacked and murdered all those Israeli citizens, has been appalling, culminating in the recent torching of the synagogue in Jackson, Mississippi, just within the past week. I believe this committee and those watching this hearing would agree that Marylanders should not need to fear for their safety or property whenever they go to worship. They should have free and safe access to their chosen religious facilities. At the same time, religious facilities should have the right to exclude those people regarded as threats from their premises. I think this past weekend in Minneapolis, I read that a band of protesters entered a Baptist church, took over the church, went up to the podium, and started screaming political chants in the church. Well, the Baptist church should have had the right to exclude those people from the church. This bill is an identical reintroduction of last year's Senate Bill 287. Delegate Rosenberg is the House sponsor of the bill. Similar to last year, this bill adopts the same prohibitions and punishments the state of Maryland has for preventing access or egress to a medical facility. It just applies it to religious facilities. This bill defines religious facilities as a place of worship, a cemetery, a religious school, educational or community facility, and the grounds adjacent to them. The operative language of the bill states that a person may not intentionally act alone or with others to prevent another person from entering or exiting a religious facility by physically detaining the other or obstructing, impeding, or hindering the other's passage. The bill explicitly excludes the CEO of the religious facility or the CEO's designee or an agent of the religious facility or a law enforcement officer. So if the religious facility wants certain people excluded, they have the right to do it. But people who are not connected with the religious facility have no right to prevent people from entering the facility voluntarily or exiting it voluntarily. So anyone who violates this law will be guilty of a misdemeanor and subject of up to 90 days in jail and to a fine of up to $1,000 or both. Last year, the Catholic Conference offered their support with amendments, and attached to my testimony today, you should find their proposed amendment, which I'm pleased to accept and urge you to accept to amend this proposed law. And with that, I'm going to give it over to Sarah Mickey and Meredith Weasel, who are going to testify in favor of the bill, following which we'll have questions.
Chair Smith, Vice Chair Wallstreicher, members of the committee, again, Sarah Mirsky-Mickey, Deputy Director of the Baltimore Jewish Council, which represents the Associated Jewish Community Federation of Baltimore and all of its agencies, here in support of SB 177, which prohibits a person from intentionally disallowing another from entering a religious facility while not prohibiting speech. Excuse me. The time is now for this. Last year, some questions were asked whether, if this was necessary. Well, the events over this fall, both in New York and in Los Angeles, outside of synagogues, shows that it currently is. Like the senator said, this is modeled after 1989 legislation around entering medical facilities. There's been no issues with that law since. Previously, before this fall and all of these things, we had issues in front of Hillels on college campuses where students weren't allowed into there. So I know last year, Senator Stidner, you had some questions about the definition of religious facility, and that is why other institutions, not just a church, mosque, synagogue, et cetera, are included. So I hope that that is helpful information for you. But for these reasons, we ask for a favorable report on SB 177. Thank you.
Thank you, Mr. Chairman, members of the committee. For the record, Meredith Weisel with the Anti-Defamation League. So we are seeing state legislatures across the country that are now looking at similar bills to this. Some are going further and doing bills related to buffer zones. Maryland, given that we already have, as Sarah just mentioned, a current law on the books related to medical facilities, is a natural way of doing this in expanding the law to houses of worship. It specifically provides crucial and legal measures to ensure that individuals can access and exit, so ingress and egress religious facilities without the fear of physical interference, safeguarding their fundamental right to religious freedom. This also does not infringe on constitutionally protected speech or activity. I just want to be very clear on that, but it recognizes a compelling interest to provide a safe and unimpeded access to places of worship. The intent is not to favor one viewpoint over another, but it sends a clear message about security and safety to our religious facilities. We are seeing this increasing, and if you look at the current statistics from the FBI, that religion-based, hate-based incidents is the highest level. 3,003 reported faith-based hate incidents are impacting all faith communities. And Maryland alone, 316 of the 921 incidents reported were related to religion-based. So it is directly a correlation of what we are seeing. And so for these reasons, we ask for a favorable report.
Thank you. Just a few questions. You just mentioned that it's not going to infringe on your First Amendments, and so I'm wondering, in looking at page 3, line 4, when you talk about grounds adjacent to, I guess, these structures, one could be exercising their First Amendment on a sidewalk. One should be able to, and they're not in that place of worship, but under this bill, they can't do that, right?
Yeah, I've been assuming grounds adjacent to them would be grounds owned by the institution that
So we're not talking about public grounds.
No, not sidewalks, not streets, not nearby parks. It's the grounds of the religious facility.
So if they're on the grounds, wouldn't that already be trespass?
It would be, but this is worse than trespass. This is blocking people from getting inside the church.
But the owner of the property would be able to have people removed for trespass, correct?
Yeah, I guess you could call the police and try to get them to do it. This.
And the other question that I had when we were defining, I mean, this isn't necessarily about what's taking place or what's being spoken within the religious facility. So, I mean, I know we're talking about worship.
About what?
We're talking about worshiping.
Worshiping.
I mean, that's been the testimony.
Yeah.
People should be able to worship free of, right. However, really the bill is about a place of worship. It's about the facility. So it could be things that could be happening within that place of worship that aren't necessarily about worship, that people could be protesting that's happening when. I mean, that's kind of where this bill is coming from, an incident like that, right?
I guess there are lots of incidents you could point to. I think what this bill does is protect the right of people who are of a particular faith, whatever the faith is, to worship freely in the space dedicated to their faith without being blocked getting in or blocked getting out or interfered with while they're in the middle of a worship service.
All right. So then that's what you're saying is narrower than what this bill is.
I don't think so. Where's the bill?
It doesn't, because the bill doesn't say that you can't do this while we're worshiping. It says it's saying you can't do this at this facility that is a place of worship.
Well, lots goes on inside a church
and that's
beyond
what I'm saying.
just the worship
Correct.
Service.
Correct.
For a synagogue, I've been to the synagogues over in Pikesville any number of times.
Right.
For public meetings,
Right.
Those things should not be interfered with.
Okay. Thank you.
Sure.
All right, seeing none, that'll conclude the hearing for Senate Bill 177 and the hearings for the day. Have a good evening.